As Trump's facing,
What are your concerns about security?
stand down.
Good morning. I think there was a sustained effort up here to hold back on all rise as you entered, so. The Subcommittee on Financial Services and General Government will come to order. The hearing is titled Budget Hearing of the Supreme Court of the United States. Members will have 5 legislative days within which to revise and extend their remarks and insert extraneous material into the record. Before we begin the hearing, I'd like to urge members to stay focused on the topic of today's hearing, the United States Supreme Court budget request for the fiscal year 2027. This is not intended to be an opportunity to revisit the court's opinions, talk about financial disclosures of the justices, or any other issues not related to the court's budget request. I now recognize myself for an opening statement. I'd like to welcome both Justice Kagan and Justice Coney Barrett and thank them for being here today. This is as close as some of us will ever get in appearing before the Supreme Court. The last time a Supreme Court justice appeared before the committee was in 2019, and we're very excited to have you here today with us. A great deal has changed over the last 7 years. New technologies have become accessible for bad actors. The threat environment facing our federal judiciary, including the Supreme Court, has evolved substantially. Chief Justice Roberts himself wrote in his 2024 year-end report that he was troubled by the U.S. Marshals Service data showing that hostile threats and communications toward judges had more than tripled over the preceding decade, and the Marshals had investigated more than 1,000 serious threats against federal justices in just the last 5 years. This committee does not take these facts lightly. We are reminded of Daniel Anderl, the son of federal judge Esther Anderl, who was killed by a disgruntled attorney at the door of his family home. And the threat to Justice Kavanaugh in 22 stopped in large part thanks to the presence of 2 deputy U.S. Marshals protecting the residents and local law enforcement support. Whatever one's view of the specific Supreme Court ruling, judicial officers, up to and including the Justice of the Supreme Court, must be able to do their jobs without fear for their safety or their family's safety. In addition to security, the court needs to be able to operate effectively and efficiently. It should have the most up-to-date information technology infrastructure and an electronic filing system that meets the needs of all of its users. It should have enough staff to research, support our justices, and the American people. This is why your appearance before us today is so important. We need to understand whether current funding and staffing levels for the court and its operations, including security, are keeping pace with the needs and the reality of the modern-day threat environment. For the fiscal year 2027, the court is requesting $225 million, a 53.5% increase above its federal FY 2026 enacted level. I look forward to discussing this request with you both. I now recognize my ranking member for any opening statement he may have.
Thank you very much, Mr. Chairman. I want to welcome Justice Kagan and Justice Coney Barrett to the courtroom, I suppose, in one sense, but to the hearing room in a very significant other sense. I also want to welcome Judge Dow, who has been so good to work with over the course of the last few years with respect to making sure that you had a sufficient budget, not only to carry out your formal duties, but also to protect the justices. Unfortunately, we put the cart before the horse. We marked up the fiscal year 27 bill in subcommittee and then marked it up in full committee before we had hearings to inform us on the facts which would make the budget decisions more credible. Now we are having 2 hearings today from witnesses about their funding request in that bill that we passed. We should have started with those hearings. We also should be hearing from Treasury and DOJ too. We did hear from OMB, at which time Director Vogt informed us that he intended to have no oversight of the damage done by DOJ. Mr. Chairman, as you know, I think we must have such hearings ourselves. As has been widely noted, this is the first time the Supreme Court justices are testifying before a House committee since 2019. We appreciate this opportunity. Such hearings used to be the norm. From 1960 to 2022, there were 93 appearances by at least one sitting Supreme Court justice every year. This is a budget hearing to fulfill our duty to appropriate the people's taxes responsibly. I imagine that the questions will go beyond the fiscal to the fundamental. Both are proper, in my view, but in the case of the court's essential independence, difficult. I want to begin this discussion today, though, on the budget by noting that the very real threats faced by our judiciary, which the chairman has mentioned, is in our mind. According to the U.S. Marshal Service, more than 200 federal judges have had threats made against them in this fiscal year alone. With a deeply divided country and increasingly violent rhetoric being directed at judges, Congress must provide sufficient funding to ensure the safety of all judicial personnel. The FSSGG bill, already advanced by the Appropriations Committee, would provide $9.62 billion for the judiciary and $207 million for the Supreme Court itself. That's a 4.8% and 7.3% increase, respectively. Included in the bill is a $28.9 million increase for court security. At the same time, while we take measures to protect the physical safety of judges and court staff, Congress also has a responsibility to safeguard the independence of our judiciary and its ability to protect the constitutional rights of all Americans. Part of that is making certain that there is adequate funding for the public defenders, and I'm glad that we were able to address the budget shortfall for defenders serving in fiscal year 26. In fiscal 27, the committee supported funding defender services at $1.79 billion, with an increase of $26 million over the last year. That is a constitutional responsibility both the courts and Congress have. The rule of law depends on a judiciary that is properly funded, especially now when we need a strong judiciary to protect Americans from the imposition of a theory, in my view, of executive supremacy. This administration is routinely engaging in conduct that tests the limits of our Constitution. We must remember that our republic is a three-legged stool. The Congress, the executive, the judiciary. I believe that each branch must be held accountable by the other two, as well as that each branch has a constitutional duty to protect the constitutionally granted powers of the other two. The American people whom we represent expect the Supreme Court and all our federal courts to play its constitutional role as a transparent and neutral arbiter of the law. Just as we in Congress must do our duty to hold the executive and judicial branches accountable, so too must the court carry out its responsibility to keep an overreaching executive or legislature in check without overreaching itself. At the same time, I believe the court has a responsibility to guard against the executive subverting the Article I powers of the Congress from usurpation by the executive. That was the founder's genius of separation of powers and the assurance of checks and balances. That is how America's judiciary maintains the trust of the people and prevents constitutional crisis. As John Adams said, we are a nation of laws, not of men. Maintaining the checks and balances to ensure that precept prevails remains the difficult but necessary job of each of the branches. In doing so, each branch will earn the structural deference our founders intended, and they believed essential to perpetuate the democratic republic they so ably constructed. Justices, I thank you and your 7 colleagues for the work that you do, and I look forward to this hearing and what you have to say today. Thank you, Mr. Chairman.
Thank you, Mr. Hoyer. I now recognize the ranking member of our full committee, the gentle lady from Connecticut, Ranking Member DeLauro, for her opening remark.
Thank you very much, Mr. Chairman, and thank you and Ranking Member Hoyer. And maybe I'll start with, may it please the court, may it please the Congress. Justice Kagan, Justice Coney Barrett, welcome. Thank you so much for appearing before this committee today. The last time, as has been said, any sitting justice of the Supreme Court appeared before this committee was in 2019. And my hope is that this sets a precedent on the role of the United States House of Representatives. I fully appreciate the unique constitutional role of the court and the immense responsibilities each of you carries as members of our nation's highest tribunal. Judicial independence is fundamental to our constitutional system, and nothing about today's hearing should be understood as diminishing that principle. At the same time, independence does not preclude accountability. Cabinet secretaries, agency heads, and leaders of independent institutions routinely appear before Congress to explain how taxpayer dollars are being spent and to answer questions regarding their budget requests, and the Supreme Court should be no exception. Each year, Congress exercises one of its core constitutional responsibilities by appropriating funds for the federal judiciary. It is therefore entirely appropriate that the court appear before this committee each year to discuss its needs, to answer questions from the representatives of the American people. As two of our nation's foremost constitutional scholars, I thank you. I thank you for recognizing that the Constitution vests the power of the purse in the Congress in bringing your budget before us today. Turning now to your fiscal year 2027 budget. No one can ignore the disturbing rise in threats directed at members of the federal judiciary. It is not lost on me or any of us the increasing prevalence and intensity of threats against not only you and your colleagues on the Supreme Court, but against judges throughout the federal judiciary. As of the 1st of July, there have been 370 threats made to federal judges, according to the U.S. Marshal Service. During the entirety of last year, there were 564 threats made. At this rate, we are looking at a 31% year-over-year increase in threats against federal judges. That is simply and deeply an alarming rise. We are not strangers here to this heightened threat environment. Members on both sides of the aisle have seen an increase in serious, credible threats of violence as well. This poses a danger not only to public officials, but to the institution of democracy as a whole. Our system cannot function without a reasonable guarantee of safety. In recognition of this need, we approved on a bipartisan basis more than $890 million for lower court security for fiscal year 2026, an increase of over $140 million compared to the previous year. In the spring, this committee passed a funding bill which included over $920 million for lower court security, a further increase of almost $30 million and equal to the amount proposed in your budget request. We are carefully considering the additional funding requested to fortify the Supreme Court and increase security for yourselves, your families, and your colleagues. We are, of course, more than happy to provide the resources necessary to ensure the safety and the security of the judicial branch. But we must be diligent in our duty as appropriators. For instance, will this additional funding for security be sufficient for the future? And how will that be measured? Will you need to come back again for further increases? Or will this be a one-time infusion, and will that suffice? This is a gravely serious issue, and we must make sure taxpayers' money is handled well. What action is the court taking to strengthen public confidence through ethics, transparency, and accountability? It is no secret that political divisions in our country have grown deeper over the past decade or more. That, I believe, is one factor that has contributed to the erosion of trust in our system, including the Supreme Court. Various scandals have also plagued the court in recent years, from leaked decisions to financial entanglements and conflicts of interest, contributing to a growing sense among the public that our government exists to serve special interests and not the public good. The proportion of Americans who have confidence in our courts has declined from roughly 60% a decade ago to around 35% in 2024, according to Gallup. A democracy cannot sustain itself if the public has no faith in its institutions. We must all work to rebuild the trust of the American people that has been lost. To restore this trust, we must provide more transparency through increased financial disclosure requirements and a binding, enforceable code of ethics. The status quo of self-policing, voluntary disclosure, and unenforceable guidelines is woefully insufficient. I say this to provide the public with the reassurance that they deserve that when a decision is handed down, it is the result of rigorous Constitution analysis, not private parochial interest. Over the past few weeks, as we have approached and celebrated our nation's 250th birthday, I've spent time reflecting on the founding and on the genius of the framers, their insistence on an independent judiciary that has, in Hamilton's words, and I quote, neither force nor will, but merely judgment, end quote, has proved indispensable to the endurance of our democracy. I believe we all share a commitment to preserving both the independence of the judiciary and the public's confidence in it. Independence and accountability are not competing values. They are complementary pillars of a constitutional democracy worthy of the public's trust. Thank you so much for appearing before us today. I look forward to your testimony. Thank you, Mr. Chairman, and I yield back.
Thank you, Ranking Member DeLauro. Today, we welcome the testimony of Justice Kagan and Justice Coney Barrett of the Supreme Court of the United States. Justice Kagan, without objection, your full written testimony will be entered into the record. With that in mind, we ask you to please summarize your opening statement in 5 minutes.
Chairman Joyce, Ranking Member Hoyer, Ranking Member DeLauro, thank you for giving Justice Barrett and me the opportunity to present the Supreme Court's fiscal year 2027 budget request. But if you don't mind, Chairman Joyce, before I do that, I would like to say a few words about Senator Graham's untimely passing. Senator Graham, of course, was a member of this House before he became a senator. And in part, I wish to express the entire court's condolences to his sister, the rest of his family, his many friends and colleagues here in the House, in the Senate, and elsewhere, on behalf of the entire court. But I'd also like to make a few more personal comments. You know, it's not very often, well, I'll just say that I didn't get many Republican votes when I was confirmed to the Supreme Court. And that's the usual state of things today. Not many Republicans vote for the nominees of somebody selected by a Democratic president, and not many Democrats do the same for someone selected by a Republican president. And one would not expect such a cross-party, if you will, vote, certainly from somebody from a deep red or deep blue state. And yet Senator Graham voted for me. And I vividly remember, because he was a vivid person, the conversation that we had in his office prior to my hearing, where he got to know me. It was a long conversation. He took the opportunity to get to know me. He questioned me with great seriousness and great knowledge about my record as Solicitor General, including particularly the various terrorism issues that office had dealt with over the time I was Solicitor General. And I still more vividly remember the conversations that we had at my hearing itself. In the last day or so, many people have talked about how funny Senator Graham was. I think Al Franken said he was the funniest man in the Senate. But what I remember about that hearing was that somehow Senator Graham made me look funny, which is a harder thing entirely, by asking me what I had done on Christmas the following year. And I'll skip the back and forth, but many people said to me afterwards, that exchange with Senator Graham was the moment my confirmation was sealed. So I want to express my gratitude towards him, not only for his support, but for approaching the confirmation process with the kind of seriousness that he did, and the kind of respect he did. And I never got to know Senator Graham very well, but I can see why so many people will deeply miss him. And I just wanted to convey that on behalf of me, and again, express the condolences of the entire court to his family and friends. We are very appreciative, Mr. Chairman, of the subcommittee's constructive engagement and support. You and your staff have been with us each step of the way as we've added security funding to meet the challenges of these times. I personally have enjoyed our regular meetings together, which have often occurred at the court. Our respective staffs also speak and share information regularly, and I look forward to our future work. The Supreme Court's funding is provided separately from the lower federal courts and split between two appropriations, one for salaries and expenses related to the daily operations of the court, and another for care of the building and grounds. We will address the operating budget today. The architect of the Capitol will submit a separate statement concerning our buildings and grounds. The court's operating budget funds the daily activities you'd expect in any federal courthouse, such as library and research services, case management, visitor services, information technology, facility management, and security. We carry out our work with relatively modest funding. Our budget represents just 2% of the judiciary branch's total funding, which in turn represents 0.1% of the federal budget. Nonetheless, we take our responsibility as fiscal stewards very seriously. In fiscal year 2027, the court is requesting an additional $14 million, a 7% increase for salaries and expenses. Over the last 5 fiscal years, the Supreme Court's funding needs have grown on average 15% per year. Aside from annual inflationary increases, recent growth in the court's budget has been almost entirely for security expenses. The majority of last year's funding increase went to shifting the responsibility for residential security of the justices from the Marshal Service to the Supreme Court Police. I first joined the court in 2010. Our security was very different at the time. The Supreme Court Police focused almost exclusively on protecting the building, and our IT department focused on supporting the latest BlackBerry devices. I didn't have a security team of my own, and I was accompanied by security personnel only when I participated in work-related public events. We began expanding our security program in earnest in 2017, initially at the behest of members of Congress. We engaged government and private industry experts to evaluate our needs on an ongoing basis. We started by expanding personal security beyond the Chief Justice so that associate justices also received small security details, much too small as it turned out. As threat assessments called for larger details, and as overtime costs correspondingly rose, we requested funding for more officers, vehicles, and support staff. As events at the Capitol and other federal courthouses revealed our building's vulnerabilities, we also added new physical security systems. When personal threats increased following the Dobbs leak, we expanded our residential security and threat assessment activities. Similarly, as online attacks grew in number and sophistication, we requested additional cybersecurity resources. Our strategy has been consistent across security functions: expand incrementally but effectively to meet evolving security challenges. We are not alone in this. Although orders of magnitude smaller, the Supreme Court's police department is modeled after your own Capitol Police Department. The two departments have matching pay tables and similar organizational charts. They work closely together on threats pertaining to the Capitol campus and beyond. They also face many of the same challenges, including officer recruitment and retention, and they have implemented many of the same solutions to address those challenges. Over the last 5 years, the Capitol Police Department's annual operating needs have increased 70%, a figure similar to the court's. For fiscal year 2027, Capitol Police requested a 16% increase. As neighbors, our two police departments will continue, I'm very sure, to work cooperatively together. Our respective departments' growing needs are obvious given current conditions. The Capitol Police Chief recently testified that threats against Congress are up 50% this year. The Supreme Court Police expect a smaller but still very substantial 38% annual increase in threats this year, which follows a 25% increase last year. For some of us, those threats have come very close, and all of us live with the knowledge that they may again materialize. But as the Chief Justice has said, all members of the court continue to do their jobs as they believe legally right, adjudicating cases without fear or favor. We are grateful to the Supreme Court Police for all they do to support our ability to do so. Again, we thank you for your invitation to come here. While we cannot comment on decisions or pending cases, Justice Barrett and I are happy to answer any budget-related questions you may have.
Thank you, Justice Kagan. I now recognize myself for questions. Chief Justice Roberts himself referenced a rise in threats in the judicial branch in his 2024 year-end report. He specifically cited more than 1,000 threats investigated against federal judges in just the preceding 5 years. Would you talk about how the volume and nature of threats against the court has changed over the past several years, particularly following the Dobbs decision and the 2022 incident at Justice Kavanaugh's home? Has the threat level changed in 2026, and what do you believe is driving that trend?
The numbers, as you've mentioned, it was up 25% last year, on track for 38% this year, and those...
Microphone, please.
Good?
Yes.
And those statistics sound abstract, but being on the receiving end of them is not. So I thought I would just share a little bit about how the threats have affected me and my family personally. They have required me to, or my children, to think about and see things that children should not have to see or think about. One example is when threats to my life were particularly intense a few years ago, around the time of the Dobbs leak. My security detail sent me home with a bulletproof vest, and I carried it into my house, put it into my bedroom, dropped it down on a table, turned around, and my 12-year-old son was standing in the doorway of my bedroom, and he wanted to know what it was and why I had it, and I didn't know how to respond because maybe I lack imagination, but I didn't expect that performing this service was going to put me in the position of explaining to my children what a bulletproof vest was and why I had to wear one. It's also been reported in the news that roughly 6 weeks ago, I was the victim of a swatting incident. At that point, my teenage son, one of my teenage sons, opened the door to go out with friends and saw in our street, it was full of police cars, who had responded to a false report of gunshots and raised voices in my home. I was very, very grateful that I had Supreme Court police outside my home because they were able to stop and meet with and explain to the county police that it had been a false alarm, and so the police did not actually attempt to enter our home. Many of us, me included, have received threatening anonymous deliveries designed to intimidate and harass us. They are often sent in the name of Judge Salas's son, who I think, as you mentioned in the beginning, Mr. Chairman, is deceased because he was killed by a disgruntled lawyer who showed up at Judge Salas's home intending to kill her, but her son, 20 years old at the time, opened the door and took the bullet instead. Her husband, standing behind, was seriously injured. So I think the message on these deliveries being sent in his name is clear. As Justice Kagan said, federal judges across the country, throughout the judiciary, including the Supreme Court, continue to do their jobs without fear or favor, but the threat level is really high.
Over the last few years, we've seen an increase in First Amendment-related activity around D.C., including the Supreme Court campus. The Supreme Court building itself has had perimeter fencing up at various points in recent years. What is the current state of permanent physical security upgrades to the building, and how much of this budget request is dedicated to capital improvements versus ongoing personnel costs?
I think, go ahead.
No, go ahead.
No, feel free.
Most of the money for this increase is personnel and not building arrangements. We have occasionally put up perimeter fences. We don't like that. We want to express a commitment to be open and transparent to the public, as I know other governmental institutions do as well. Occasionally, we have found it necessary, given the threat level, to put up some barriers, but they come down as quickly as we can take them down. Some small part of the funding request is for building improvements, but mostly it's for security personnel.
Protecting the court and justice involves coordination between the Supreme Court police, obviously, the U.S. Marshal Service, Secret Service, Capitol Police, and local law enforcement, depending on your location. Would you walk us through how those responsibilities are divided and whether there are any gaps or redundancies in the structure that we should be aware of?
We are primarily taken care of by the Supreme Court Police. When we needed additional residential security and the Supreme Court Police was unable to staff that, the Marshal Service did help us, and so our homes were protected by the Marshal Service. I might be wrong about this, 2 years or so. The Marshal Service was not able to sustain that level of support, and so they asked the Supreme Court Police to take that over, and the Supreme Court Police is now doing that with the help of contractors. We coordinate with Marshal Service, sometimes in travel, but really the Supreme Court Police does the bulk of it. And I think for physical safety, there's coordination with the Capitol Police, given that our grounds are so close.
And I should say, we like it that way, to have our own police force rather than to be reliant on the Marshal Service, which is within the Department of Justice. This way, we just get more control over our own security arrangements. Some of you may recall that last year we asked for a supplemental request, and that was to deal with the problem that we had thought that we had a longer stretch of time to make the transition between the Marshal Service and the Supreme Court Police. In the end, we had to make it more quickly than we thought we would, and we're very grateful to the various committees in both the House and Senate for making sure that we had the supplemental monies that enabled us to make that transition more quickly than we had thought was necessary.
Thank you. I now recognize Ranking Member Hoyer for any questions he may have.
Thank you very much, and again, thank you for your testimony. We're all very concerned about the security and the safety of our judiciary, not only because of you individually, but because of the impact it would have on our system. And the disincentive for people to serve in the roles that are so critically important to our society. Let me go to the staffing. You said the pay levels are similar to the Capitol Police, and that they obviously work together and interface together. Is your budget now sufficient so that you will not have contract employees, outside contractors protecting your homes?
Not at this point. The goal is to be able to staff so that we can entirely absorb residential security within our office, and I'm sure our staff can provide more details about the timeline for that, but at this time it is not.
Will the budget that is projected for fiscal year 27 allow you to do that? Do you know?
I think still not, but we will be getting closer.
Good.
And certainly our goal, and we want it to be as a short-term goal as we possibly can, is to get to the point where we're not reliant on any outside contractors.
I think it's critically important to have people who really know you, your habits, your to and froing.
You are speaking to the choir there.
Well, as someone who had a security detail for 20 years in my previous positions, I found it critically important that they got to know me and my habits and the habits of my family, and made them much more proficient in protecting. So we want to make sure that that's the case. Let me go to, and I'm not asking you about the substance of decisions, but I am asking you, there has been a substantial increase in what I guess we call shadow decisions. Is that a budget-related or policy-related phenomenon?
Well, let's see. I think that litigants have long had the ability to seek interim relief from the court, but I think you're certainly right, Ranking Member Hoyer, that we have seen a big change in the volume and the nature of such requests. The court is doing its best to adapt and respond. I think it's a policy question, not so much a budget one. I don't know if you have additional thoughts.
I'm sure there will be additional questions.
Does that impact on the transparency which you referred to, not putting up fences so that people had access? There are concerns, obviously, that these shadow dispositions impact adversely on the knowledge of the public has about how the court makes its decisions and who is making what decisions. Do you comment on that?
Ranking Member Hoyer, there are definitely issues with respect to we call it the emergency docket. Some of us call it the interim docket. It's a terminology nightmare. I call it the emergency docket. And there are definitely questions about how it's appropriate to use that docket, when it's appropriate to use that docket, the standards to be applied, the way those standards actually work out in individual cases. And you see that in some of our decisions, because we are, in many, if not most of these cases, not unanimous. There will be a majority and a dissent. The reason I think it's probably not appropriate, at least not now, to call it the shadow docket is because we have done, I think, a better job in the recent past of where appropriate, and it's not always appropriate, but where appropriate, explaining ourselves, at least to a moderate degree. So I think if you had asked me this question a year ago, I might have said that there were some cases, and in fact I did say, I had said in some public events that there were some cases where we did so little explanation of what lay behind our order that lower courts had a great deal of difficulty trying to figure out what that order was. Were we saying something about the merits of the case? Were we saying something about who had standing to contest the merits? Were we saying something about appropriate remedies? Nobody knew. I don't think that that's so much a problem anymore. I think that as we've gotten more experienced in these constant requests that are coming to us about requests for emergency relief, that we better recognize that at least sometimes there is a need for additional information. And we have issued opinions and sometimes majority and dissenting opinions accordingly.
Thank you very much.
Thank you. The chair now recognizes Mr. Amadei for any questions he may have.
Thank you, Mr. Chairman. To provide some context, obviously security is probably rightfully so at the top of the pyramid as we discuss the court and its budget. How's business? I mean, you know, anybody know where you are? Anybody filing this, that? And you've kind of touched on it a little bit in response to Mr. Hoyer's questions, but to have an idea of how things are running in the machine of, well, we got 9 justices, and here's who comes to us, and here's what we're doing, here's what we're turning down, here's what we're accepting, just to have kind of a background context to this discussion about security. So however you want to address that,
Sure.
How's business going?
Yeah, well, business as usual, or maybe not as usual. So we do everything we can to be transparent and to welcome the public into the court. We've really taken strides in adapting our website to make it more user-friendly. So people can come to our website. They can easily access all the briefs, all the opinions. The website also has information about who the 9 justices are, the history of the building, that sort of thing. Our courtroom is open to the public. We routinely have public courtroom lectures to groups that are coming in. I believe all of my colleagues, I know I do, speak to groups and school groups that come through to educate them about the court. Our curator has exhibits throughout the first floor of the court to educate people about the court, including a wonderful exhibit that's up about Cooper versus Aaron. We have the Cooper bench from the famous case that's out in the court right now, complete with a video explanation of it in which all 9 of us participated. So I do see a need for educating the public about what it is the court is doing. And so the court, I think, has done its best to try to make that accessible to the public.
Great, thank you. How about caseload? What's the case? I know threats are way up. How's caseload?
Well, we have, as Ranking Member Hoyer suggested, we have a more than ordinary emergency caseload. I would say we have about an ordinary regular docket. If you look back really a number of decades, our docket has gone down. You know, when I clerked at the court, so that was, I'm afraid to say how long ago, but in the late 1980s, the court handled about 140 cases a year. The court now handles, in terms of regular argued cases, maybe 70 cases a year, so a significant decrease. There's a cottage industry and explanations for why that decrease took place over time. But for all the time that I've been on the court, we've been relatively stable. So the last 15 years or so, we're doing about, maybe 1 year at 75, 1 year at 60, but something on that order. So we continue to hear cases every month and to always decide, always issue all our opinions before July 4th every year.
Thank you. I yield back, Mr. Chairman.
Thank you, Mr. Amodei. The chair will now recognize the lovely lady from Connecticut, Ms. DeLauro, for any questions she may have.
Thank you very much, Mr. Chairman. And just a point before I get to my questions with regard to the exchange with Justice Kagan and Congressman Amodei, it would appear that these are the court statistics. In 2006, there were 10,256 total cases. In term 2024, 45, almost 4,600 cases. So it is about a 55% decline. I have to imagine in analyzing that.
This is in petitions, are we talking about?
Yeah, so that it may be that what happens there is the interim shadow, whatever docket we're talking about here, that may be a part of that. So that there has been, in a fewer cases than you pointed out that have happened in prior decades. And then the issue of staffing is how commensurate is then the staffing to what the case is. But let me just, and I won't get into this, but in terms of, there's always the view out there of what about cameras in the court, so we have them everywhere here. But as members of Congress.
Is that good or bad?
Okay, I'll take a breath on that. No, it's.
I'm sorry, I didn't mean to turn it around.
No, what you were very good. It's very good. It's called transparency. Anyway, my questions. As members of Congress, we follow very strict gift and ethics rules. We're not allowed to accept any gift if it's over $50 at one time, and there's a total value is more than $100 in a calendar year from any individual. There are exceptions, and an entire committee, we have an ethics committee that decides whether a trip or a gift is allowed. But as justices of the Supreme Court, you can and do accept these gifts without any committee or without hesitation, or maybe there's hesitation, but in any case, you can accept these gifts. The Supreme Court does not have a gift ban or a binding code of ethics. I know in 2023, a voluntary code of ethics was adopted, but it is entirely self-policing without any mechanism for enforcement. It is more permissive than the code that applies to all other federal judges. And just in full transparency, I strongly support Ranking Member Raskin's High Court gift ban, which would bring the Supreme Court justices' rules in line with the rest of the federal government. Based on the financial disclosures available for the justices, tickets and trips have exceeded this threshold of the which is in the voluntary code. This last year. So a couple of questions from this. Is this a time to make this a requirement instead of a suggestion? That's my first question.
You want me to do gifts? I can do. Ranking Member DeLauro, I would be happy to address the question about gifts. The court follows the restrictions of the Judicial Conference of the United States applicable to all judges with respect to gifts, and we are not, there are restrictions on our ability to accept gifts. We are not permitted to accept gifts with, some nuances and some exceptions from litigants before the court. And any gifts that we do accept, this is by statute. There's a statutory limit on reporting that requires reporting of any gift. I think that the limit is about $500 right now. You would know, they would be on our financial disclosures because we have to disclose that. So with respect to gifts, we do have constraints, and we do have our in-house counsel. I mean, anytime I have any question about how the code applies to a particular circumstance, I always call him. Did you want to address enforceability?
On the code of conduct, as you noted, we the 9 justices all agreed to a code of conduct. It's specifically geared towards the Supreme Court. As you also noted, there is a question about enforceability, and right now the mechanism has no enforceability system. And this is something on which various people have spoken in the past, and I've made my views known in the past, which is that I think we should work hard to try to figure out some enforcement system. I will say that that's an extremely difficult question for a pretty obvious reason, I think, which is that I don't think that you would want an enforcement system that was controlled by the executive branch or by the legislature. And this is because of what you said in your opening statement about the importance of judicial independence.
Right.
You don't want a president picking an inspector general to decide, which of us is breaking the rules or how we're breaking the rules. So I think it really has to come from within the judiciary, and that's hard because, we sit at the top of the Judiciary Committee, so it's hard to figure out how to have a system that makes use of judicial resources to police us. One idea that has been suggested by some people is to use respected retired judges.
Right.
That has, some pros, some cons. I think that this remains an open question, a question of discussion. But so far, we have not resolved anything.
Okay, and
The chair
because,
now recognizes the gentle lady from Iowa, Ms. Simpson.
Good morning. Thank you to both of you for coming before our committee today, and you were so welcoming to this full committee when we came over to visit with you a few years ago and to have some of these similar conversations about your security needs. And I'm so sorry you're having to deal with many of these same threats that members of Congress and our families also deal with. And Justice Barrett, you were sharing that story about your 12-year-old. My boys are 13 and 15, and so I've had to have some of those very similar uncomfortable conversations with them about our security posture, even in the middle of Iowa. So I am sorry you're having to deal with that. I think reasonable people can disagree, and unreasonable people resort to violence, and unfortunately, that's where we are. And so I appreciate your comments on that, and no, you are not alone in dealing with those challenges, but it is unfortunate nonetheless. I wanted to follow up on something you started with about the coordination with the marshals when you're traveling for speeches, because you talk about having the Supreme Court police force, but obviously working in coordination with other law enforcement when you're traveling for speeches, some of those teaching opportunities, other engagements. So we know that those are not immune from protests and First Amendment activities as well. Can you speak a little bit to what that work is like in terms of coordinating on the ground as you're traveling the country to have some of those conversations on the ground?
I think some of that coordination might be something we would have to say that if you wanted to talk in a skiff or with staff just about the operational details. But I think at a high level, I can say that when we are, appearing, say, at a university, there's a lot of coordination, obviously, between the university security staff and our security staff. The same is true whenever we're at an event with local police. There's coordination with local law enforcement authorities. And when we are interacting with other entities within the judiciary, lower courts or at circuit conferences, then there is a lot of coordination with the Marshal Service. I think some of the specifics I probably don't know enough to speak, with specificity, but probably would have to say that would be like in a private meeting.
No, absolutely, and I think happy to have a further conversation about that, because simply we just want to make sure that you feel safe as you're going out and exercising your duties to be open to the public, right, and have those conversations in a public setting. It's of utmost importance that you can do that and feel safe, and that you're getting adequate law enforcement response on the ground, no matter where you're having those conversations. Speaking of recruitment, I just kind of wanted to talk about that as well, because you mentioned that you're on par with Capitol Police, and many of the arrangements are similar to what Capitol Police are. We know that the court's currently offering a $60,000 hiring bonus for Supreme Court police. Can you speak a little bit to the difficulties that you're having in recruiting top talent to take some of these open positions, and where things currently stand with?
Yeah, well, this is a tough time to hire police officers. It's a challenging recruitment environment that maybe fewer people are going into the policing profession, and so you're competing with a lot of entities for the same top qualified people. Notwithstanding that, we've managed to do pretty well. We do offer a recruitment bonus. We like to think we're a pretty good place to work, and we take great care to make that so. But it's a challenging time.
And how do you balance, obviously, that recruitment with some of the risks that, I mean, people very publicly see, right? And you're the face of that, obviously, in not only the decisions that are made, but obviously people come and see the court and people come and want to hear from you. How do you balance that recruitment with some of those risks in terms of getting people in the door?
Yeah, well, people definitely come in the door. I mean, we are, we have many visitors to the court. We have a packed courtroom most of the time when we hear argued cases. So we're trying, very hard not to let it interfere with the court's openness to the public, and we'll continue to try our best to do that, and just to make sure that we have the security personnel, the security resources we need to ensure safety within an essentially public building.
And just a question about, and maybe it's something that needs to be addressed in a SCIF as well, because you think about the limelight that's on you, and that may shift depending on a case that's being heard or a decision that's been offered. Do the number of officers or marshals assigned to you vary dependent on that limelight, or is the detail pretty consistent no matter who you are?
We are each assigned between 4 and 8 members of a security detail, but in particular moments when the need arises, and especially if someone is under particular threat or if they're speaking more publicly, so they're more in the limelight in an event, that number increases and we're able to pull from other resources within the court.
And over time, we'd like that detail number to increase. So if now it's 4 to 6, maybe 8 members of a security detail, we'd like to increase that over time when we get to our full staffing needs.
And as Ranking Member Hoyer had spoken, and I know I'm out of time, Mr. Chairman, these people get to know your routines, and making sure that you have people on your detail who are familiar with your activities is critical. So thank you, Mr. Chairman. I yield back.
Thank you, Mrs. Hinson. Chair now recognizes Mr. Pocan. 5 minutes of questions.
Thank you, Mr. Chairman, and thank you both for being here. I couldn't make our most recent informal conversation, but I remember a few years back, you both were very generous with your time, and I really appreciated that discussion, so thank you both for that. I think there's no question that any of us, there should be no partisan difference in wanting to make sure everyone's secure. We have our own challenges, as you've heard. I think holidays seem to bring it out for at least members of Congress, or in my area. At Christmas time, we had bomb-sniffing dogs. I was wondering if I was going to start having to have treats out there for them if they were going to be coming that often. My brother's a judge in Milwaukee County. There was a court trial over someone who had threatened his life via phantom family court. So, I'm glad you're here to talk about those security concerns, but I think hopefully you can tell we're like one party right now when it comes to this and making sure that you have that security. I do want to say, though, I think at a 30,000-foot level, public also has some questions about our institutions, and incumbent on us then is to make sure that we're at times either explaining or reforming to meet where some of those concerns are. Right now at the executive branch level, I think people are seeing some unprecedented amounts of new things happening that in 250 years as a country haven't happened, and that's causing concern. Here in the legislative branch, I would argue, I think people think we've lost our copies of the Constitution and that we're a co-equal branch of government. We're not doing our jobs. But I think when it comes to your branch, specifically, the 2 areas I hear the most, and I do a lot of town halls, are the shadow docket or emergency interim docket, and then the issue around code of conduct. But shadow docket's one I really like the explanation. I'm not a lawyer, my brother is, but the amount of cases that you took up last year were surpassed, or the last session were surpassed 63 on the so-called shadow docket versus 56 on the regular. And if you go back in history during the Bush and Obama Solicitor General times, emergency relief was only done 18 times combined over 16 years, right? So this is a huge change in how this, and I'm going to use shadow docket because I'm a journalism major. I was taught to talk at 8th grade level, so everyone understands it. That's the vernacular I think people understand. But they're not really fully briefed. They're not fully argued opinions in the same way I think that people are used to the tradition of the respected tradition of the court. They're unsigned, usually emergency orders, but that definition of what's an emergency certainly seems to have changed given the number of cases. It usually was elections or like someone was on death row when you dealt with this, and now it's about whether trans people can serve in the military or cases that may not be seen by the public in the same way. So my question is just help me understand this. There's, I have a podcast and we had a conversation on this with an expert one time, and they said a few suggestions they had. And let me run this by you. And if you could just talk a little more about this so I can understand why the cases have gone up so much. They suggested things like restoring more mandatory jurisdiction to the court so that you're not maybe cherry picking in some ways, empowering lower courts to seek guidance from you ahead of time. So maybe sometimes that could take care of things. An inspector general for the judiciary. Anything you want to talk about? Those are some things that came up, but I would like to be able to explain to people next time I have a town hall and people ask about this, why this rise has happened in areas that I don't think we really expected those cases. And while you said there might be a decline, I think just this Trump presidency alone, in 16 months, there's 34 of these? Maybe my number's off. It might even be higher by now. There were 41 in the first Trump full term. That seems like a rapid expansion of this. So I talked too long, but if you could address that, I'd appreciate it.
Thank you, Congressman Bocan. I'll address something about the numbers. And I saw something about this in the news in the last couple of days. I'd have to sit down to figure out the numbers. I think that it could be that what the numbers are referring to are, we have mandatory jurisdiction in a sense over all of these emergency applications because every single one of them, we have to either grant or deny. So to the extent that we've disposed of, say, 67, I'm not exactly sure what the number is, some of those may be denies. It's not that there were 67 grants, but in every single case, we wind up doing something on the emergency docket because we've either denied relief or we've granted relief. So, as long as we have that jurisdiction, we don't have the discretionary jurisdiction like we do on the merits docket where we have cert authority and we choose which cases to take. On the emergency docket, it's like you just take all comers and you have to grant or deny these motions as they're filed.
I didn't mean to suggest, Mr. Congressman Pocan, that the overall numbers had declined, just that there was a decline in the when we grant relief with no explanation, that we do that less frequently than we once did. But I think, you've made some excellent points about there are downsides of using emergency relief, that we don't get the kind of briefing that we ordinarily do. We don't get the argument that we ordinarily get, and we should consider those downsides when we decide how often to grant this relief. Now, I will say that the court, again, as its question is like, why are all these people coming to us for this relief when they didn't in the past? I think partly it has to do with the fact that the court did grant some of these petitions, and then you encourage everybody else to bring them to you. And now it's become, you said, like, how's business? How's business? Is like, business is pretty good on this side because people see that there is at least a potential for us to grant relief, and so why not file a petition? And the court, I think, again, has, and there are differences, there are disagreements among the 9 of us. We talk about this all the time. Sometimes a majority does something and there's a dissent. But I think over time, we have at least tried to do better in important cases, ensuring that we have some degree of sort of regular-ish process, so that there are some emergency petitions. For example, the one that was just decided involving the Federal Reserve Bank, which we almost treat as though it were a regular case. In other words, we ask for argument, we make sure we get sufficient briefing to decide it. So occasionally we've done that, and that is something that I think we need to consider going forward as well.
Thank you.
Thank you, Mr. Pocan. The chair now recognizes the gentleman from Texas, Mr. Cloud, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Justices, for being here. It's great to see you again, and thank you for the opportunity we've had to speak with you about this over at your place a couple times over the last few years. Most of my questions have been addressed in those meetings regarding security. I did want to just point out that this is not just, it's your personal security, but it's also the IT systems that need to be updated. It's the cybersecurity that you're constantly attacked that's also being addressed in this as well, correct?
Correct. The cybersecurity attacks have been up, by magnitudes year after year. AI is, and the rapid advancement of AI is making that more and more possible. We haven't suffered the kind of paralyzing attacks that some of the lower courts have, but in seeing that has caused us to try to ramp up very quickly our cybersecurity protection. And so some of the funding that we're seeking is for additional cybersecurity experts who can come in when we've tried to proceed very responsibly. We've consulted, we had an external review done by experts, and then we've assembled a tiger team inside the court to try to implement those suggestions, because it obviously impacts not only the independence of the judiciary, but their national security risks to having our systems be vulnerable.
One of the big issues recently was the leak that happened, and the court was doing its best effort with the tools available at the time to track down the leak. I don't know if we've found the leaker yet. I don't think it's public.
The marshal issued a report at the conclusion of our internal investigation saying that we had not at that time. But
right.
yeah, she also said in that report that were additional evidence or leads to surface, that they would be pursued.
And there have been additional leaks over time, too, and this is something that all 9 justices take extremely seriously, because we can't do our business, we can't engage in confidential communications, which is the best way to operate, is to be fully open with one's colleagues about one's views. If you think that those views are going to appear on the front page of a newspaper, you pull back. You don't have the kinds of conversations that I think the court really depends on to do great work. And this is something that has frustrated all of us, and that we're continuing to make efforts to resolve.
Is it your view, if there's a police force that reported directly to the Supreme Court that would include cybersecurity officials, I imagine, or any of the sort, is it your view that they would be subject to congressional subpoena, or would that be a separation of powers issue?
I don't think we are authorized to express a view on that.
Okay. One issue I do think that Americans are concerned with, and it's really appreciative to have you here. I wish we could have more of these because of our constitutional role, to be a check, in a sense, on, not necessarily on you all, your decisions certainly, but on the judiciary system. Is one thing that's really concerned me is what we've seen in nationwide injunctions, what we've seen in what's been lawfare, in the sense of we've seen lawyers who were supporting the president be disbarred, while those who campaigned and even attacked him invented extraneous legal platforms to go after him. There was no disciplinary action at all. And what concerns me about that is the ABA, the American Bar Association, doesn't serve officially as a gatekeeper, but in many ways serves as a gatekeeper, which traditionally that hasn't been that big of a deal. But they are the only they're the only accrediting agency for law schools recognized by the federal government. Yet lately they've kind of taken a partisan bent on a number of their policy outcomes and initiatives, including transgender surgery for children, advancing DEI requirements for accredited universities for law students. They even targeted universities who did not embrace those. They're weighed in on immigration policy, voting rights, opposed the display of 10 Commandments in public schools. They have opinions on a number of different international issues, including urging support for the people of the Western Sahara, self-determinant. So it's all that to say, it's gone beyond making sure that we have good people who are qualified representing us, yet they serve in many ways as a gatekeeper. And I'm curious what would be the right way to approach that. Texas Supreme Court, I know, issued an opinion that basically said they shouldn't be the sole gatekeeper anymore, at least for Texas is concerned. Whether we should have more creditors, whether we should leave that to the states, I think there's a congressional role in this, and so that's why I'm asking.
If I may, we have a hard stop of 11:45 because the justices need to go over to the Senate and testify there. I want to make sure everybody gets their 5 minutes. So, and if you can respond to that in very quick order, or we can move on to the next questioner. It's
Up to you.
It's up.
I'll say something very quickly. Each state is in charge of the admissions of bar requirements for lawyers, and so I think that lies with the states.
Thank you. Now recognize the gentle lady from Washington. Mrs.
Thank you, Mr. Chair, and thank you both so much for being here. One of my concerns with Congress's increase in the security funding for members of Congress that we recently executed here was that it's not really addressing the root cause of the increased threats of violence and the underlying sort of lack of accountability for people making these threats. I don't want to make soft targets out of my local electeds, my teachers, my nurses, because we are hardening our security infrastructure as elected officials. If my kitchen is flooding, I turn off the water before I start mopping up around the kitchen. And so I'm wondering what can be done to increase the prosecution and accountability of those who make threats against public servants, and how can these funds and this appropriation be leveraged to support that prosecution and turn down the volume and increase the accountability, because all taxpayers are bearing the burden of these threats.
I think that that's largely a question to make to the Justice Department and to other prosecuting authorities. That, we have no power to prosecute or not prosecute particular crimes, to decide where the priorities lie, and that might be that incredibly important question might better be addressed to prosecuting officials.
One of the things I've wondered about is, none of us want to talk about the threats that are made against us. We don't want to give anybody ideas, right? Especially having young kids at home. But one of the questions is the evidence that's collected by Capitol Police. How can their investigation be executed in a way that would provide supporting evidence for a prosecutor as they're considering picking up this case or not? Is that in the realm?
I think that would be something that our police department would be very happy to talk to you or your staff about in a private setting. I actually don't know the answer to that question of what the police do to maintain evidence to build a case. But I'm sure in a SCIF or other private setting, that would be something that you could explore.
And would that be considered as part of this apportionment for security funding?
That I don't know. That strikes me as general operational. As Justice Kagan said, we don't have any authority to prosecute within our branch, and our police don't either. So that seems like it's a best current practices question about how the police handle that now.
Yeah, I mean, it's my view that as we are, it's not just about the individual threat. We have to maintain our security, but the way that we are pursuing that security should be done in a way with a longer view towards more accountability and better use of taxpayer resources and a more deliberative democracy. I've seen some people make the argument that rising security concerns will lead justices to opt out of appearing at events when the crowd is known to not be friendly. Do you think there's any merit to that argument? And if so, how does that impact the credibility of the institution as it continues to be viewed, rightly or wrongly, by many as increasingly partisan?
I can say that personally myself, I've spoken at many events that I wouldn't describe as friendly. I've been protested a lot and spoken at events where I know protesters will be. And that doesn't deter me from appearing, but if there were serious threats at the facility, I've encountered some of that before, then of course you can't remain out in the public place. And that's different. And I don't actually know, and again, this would be a question that perhaps could be discussed in a private meeting or a SCIF. I don't actually know how often that has happened, but I think when there are actually threats to life, then obviously the public event can't go forward.
I think it's I'm presuming rare for a Supreme Court justice to have young children at home. I'm wondering, Justice Coney Barrett, if the allocation being made here for security is sufficient for provision of security services for your children.
I'm very grateful for the residential security. I think that is the primary, I mean, that has just been huge for us. I think questions about the allocation of resources and the number of detail and that sort of thing, I think I would refer that to the SCIF as well.
Great, thank you.
Thank you.
Yield back.
Thank you for your questions. We now recognize Mr. Edwards for his question.
Thank you for being with us this morning. Because we're running close on time, I'm going to eliminate the niceties and get straight to the questions. Does the court's IT budget include funding for AI-assisted legal research or document review tools? And if so, what safeguards are in place to maintain confidentiality?
I don't think that our review budget, that our budget includes a specific, appropriation for AI. I think that, this is a question that we're looking at very closely in terms of what our rules should be going forward, what the best practices in this area are in terms of how justices, how their clerks, how their assistants use AI, and make sure that it's used appropriately, but not used on where it's likely to create more dangers than anything else.
Have you identified any other opportunities to streamline administrative functions through technology or maybe even shared services?
I think the court is always seeking efficiency, and I think we operate on a pretty lean staff in terms of how our technology works. I mean, I do think that our IT staff works very hard to make things work efficiently on the inside. As Justice Kagan said, I mean, I know a lot of corporations and maybe Congress too are turning to AI to gain efficiencies, and we're not there yet because of the risks that AI could present, but it is something that we're studying. And, perhaps AI seems to be infiltrating everything, so I'm sure at some point in the future.
I resist using the letters AI. It's so abused. I'd rather just say new technology. But thank you. Speaking of staffing, how many current unfilled positions are there in the Supreme Court? And can you give us any perspective on what those are and how long that they may have been vacant?
Okay, if you know that, you're better than I am.
I do not know that. Does anyone know that? I think we'll have to get back to you on that. We can send something over.
Well, as an appropriator, I'm always really curious about that sort of thing.
We have we have an incredibly, the amount of time that people spend on the court constantly amazes me. So every year we have these events where we give little pins to people and so forth, and especially when they retire. And they, it's like 30 years on the court, 40 years on the court, 25 years on the court. So this is not a building which is in constant turnover in terms of its employees. There is really long-term service in this building. I think people like to work there. I think people feel honored to work there. And the result is that we really don't have to worry about a lot of turnover.
Last question on the appropriations front. Have there been any recent audits or reports by the AG where there were any material weaknesses found that have not yet been resolved?
Material weaknesses in our expenditures or budgets?
Right, the total operation of the Supreme Court.
Is that a no? No? That's a no.
Okay, well then, since that answer was so quick, let me ask.
I should have dragged it out.
Let me ask one more question. What deferred maintenance or capital investment is there still listed as a backlog, and is that for public consumption?
I think that the budget for the grounds is not part of our current security, our current budget request, so I'm not sure what maintenance or grounds expenses would be included in that, the architect of the Capitol.
All right, thanks. Next time, we're going to bring your controller. Thank you for being with us.
Thank you, Congressman.
There's a severe backlog in all federal buildings as far as deferred maintenance. Now recognize Mr. Ivey for 5 minutes.
Thank you, Mr. Chairman. I appreciate that. And thank you to the justices for joining us today. Wanted to follow up on the shadow docket issue, emergency docket issue.
We're not policing your vote. All right?
Call it whatever you
Call it
want.
whatever you want.
I recognize the sensitivity about it, but I do, and I thank you for your comments about this. We found comments that you all had made at public events, and so I thought it's something that I could raise. One of the things I wanted to ask about is with respect to the injunctive relief, temporary injunctions that were put in place that had come up to you all, and you all looked at irreparable harm. I think Justice Barrett, you'd kind of noodled about this publicly on a couple of occasions. And I wanted to get your take on that, because just to be candid, I represent Prince George's County. We have tens of thousands of federal employees who've been laid off or forced out during this time period, in part during what's been going on with the litigation in these cases. And frankly, the strategy for many of these was, if you can get injunctive relief for them so they can stay on the job, at least they can, keep their house, keep their kids in college, make sure they can put food on the table. To the extent those injunctions were lifted, because I guess some of these don't have opinions, but I guess some of the justices thought that this didn't constitute irreparable harm. It was pretty damaging from the perspective of them. And it looked like the analysis was focused mainly from the government, the Trump administration's perspective. So I wanted to get your take on that.
To me?
Well, yes, ma'am, but to both of you.
Let's see. So I think the specifics of individual cases are something that we're not prepared to get into in the hearing, just because that would be, especially, I don't know exactly which of the orders that you're talking about, but especially if they were unreasoned orders, then to talk about the reasoning of them would disclose the internal deliberations of the court, which would be inappropriate for me to do. I would say that in our opinions, including in our emergency docket opinions, we lay out the factors that are considered, in considering grants of emergency relief, and irreparable harm is one of those factors, as is likelihood of success on the merits, balancing of the equities. And so I think the factors are laid out quite plainly, how they apply in any individual case, or how we have applied them in individual cases. I wouldn't want to.
That's fair, but I'm not asking specifically for individual cases. Is there a general approach from your perspective? Because you did lay out irreparable harm as one. And I think you also mentioned in one of your September 9, 2025 speeches that you did look at it from the Trump administration's perspective. Go ahead.
Please finish.
I wanted to see if there's also a view from the perspective, in this instance, is the plaintiffs who, or the parties who were government employees or whoever, who were on the opposite side of that.
Okay, I now understand your question. Yes, those factors, they're from a case called NCAN. Those factors, it's built into the test itself that you gauge irreparable harm, likelihood of success on the merits from the point of view of the applicant. So if it were the employees, if they were the applicant, it would be the irreparable harm to the employee of not receiving the relief that they seek. If the person who seeks emergency relief is, say, the government, then it would be evaluated from that perspective. That's just built into the test itself, which is in the opinions in the cases.
I do think, though, that the test also has room for what we call the balance of the equities. And that allows you to take into consideration also the what's going to happen to the non-applicants in any given case. Now, again, how that happens is a different question.
True.
Excellent. And just another quick point on that front. For example, NIH, I want to ask you to answer this about the particulars of it, but one of my constituents had been a scientist doing research on Alzheimer's. And the clinical trial was shut down and she was forced out. And so it terminated not only her work, but the scientific research that we would all benefit from. 2 quick points before I run out of time. One is the Secret Service, from the standpoint of your work with respect to your protection. We did a lot of work. A committee was set up after the attempt to assassinate President Trump. Well, not candidate Trump then. And there were a lot of deficiencies found, frankly, by what the Secret Service had done. I think they've improved what their work is. I'd encourage you to have your police team do that. And then lastly, I know you answered with respect to Mr. Pocan, the ethics
Your
piece.
5 minutes are up, please.
We'd
Thank
love
you.
to hear
We
about
now
what's
recognize
going
Mr.
forward
Alford,
with
please.
Thank you, Chairman Joyce and Ranking Member, and thank you for the justices for coming today. Really appreciate that. I do want to set the record straight as we begin, though. While we all love hearings before we vote on the appropriation bills, we have a very aggressive schedule for these appropriation bills. The chairman's objective was to finish them all before the end of June. We actually got them done by mid-June. That facilitated the need for rapidity and trying to make sure that we got as much information as possible. Part of that included coming to the Supreme Court on March 5th, and we discussed many of these things. This was a bipartisan effort to go with your invitation to come and hear your budgetary needs. And so I appreciate that endeavor. I appreciate the members of this subcommittee who did go across the street to hear your concerns. And we heard some very disturbing deficiencies. And while we can't talk about all those in this public setting today, please know that those are noted. Those were included in the consideration for the appropriations bill that we did complete. And one of the issues that came up was the need for a security entrance for the Supreme Court building. Justice Kagan, could you describe what this will look like, and did we provide the adequate funding to make this happen?
I think we don't know exactly what it would look like, but we are concerned about people coming into the building right now before they've been checked, essentially, and only being checked when they're in the building. And we're concerned as well with the ability to enter for cars to enter. We've actually gone a significant way in addressing that issue, essentially by closing off the street behind the court. And we're very grateful to local authorities for their willingness to do that.
I think the point we made at the time is we have the beautiful visitor center here at the Capitol that was in part a security concern. It's also a great visitor center. It would be kind of mirrored in a smaller fashion across the street of the Supreme Court, and also what the president has proposed with a new security entrance to the White House with a ballroom on top, but a security measure underneath and a bunker. So thank you for clearing that up. One of the things I did mention at our in-person meeting, which again I'm grateful for, was a growing concern about the threats that drones pose to government buildings and protected officials, not just across the street at the Supreme Court building, but at your homes as well. How is this Supreme Court preparing for that evolving threat, and are there any additional authorities or resources that we should consider to make sure that you are protected?
And if you would like to, we could do this in a skiff at a later time, if you feel that it's something that needs to be addressed there, or if you want to
I
address
would
it
say generally that we
Generally.
share that concern. Generally, I think drone mitigation measures are certainly on security's radar.
Well, we want to keep on top of that, and Chairman, maybe we could do something in a SCIF setting to where, this is a growing threat to all government officials, and it doesn't matter what party you're in, nonpartisan. This is a threat that needs to be addressed.
And I think, Congressman, that there might be ways to address whether we have all the authority we need currently, or whether there needs to be additional statutory authority that would really allow us to deal with that issue.
That would be an interesting conversation. We're facing that here on the Hill as well, and in our state and local authorities. We just are wrapping up the FIFA World Cup in Kansas City, and that was a concern as well, the authorities to actually defend against drone activity. Last question. The court budget request in recent years has included increased security funding for the justices. Public threats against government officials have continued to rise. You travel for speeches, teaching opportunities. How is security funded and coordinated when justices are traveling, particularly with respect to protecting your families?
Residential security remains at our house as normal. When we're away, the house remains protected, so the family is protected. And when we travel, we have our security details travel with us because, unfortunately, the threat travels with us it doesn't just stay at the building.
If there are any gaps in that where it needs additional funding, please let us know, all right? And with that, I yield back, Mr. Chair.
Thank you, Mr. Alford. Chair now recognizes the gentleman from Georgia, Mr. Bishop, for 5 minutes.
Thank you very much, Mr. Chairman. Thank you to the Associate Justices for your appearance. And let me say at the outset that I fully support and appreciate the need for the upgraded security that has been requested, and I think Congress will be responsive. The Supreme Court contracts many of the security services, and for example, you contract with the Chertoff Group since 2018. The services it's provided include consultation on protecting your homes, on review of the Dobbs leak investigation that was conducted by the Marshal's Office. In addition, the individuals who man the magnetometers at the court entrance are not members of the Supreme Court Police, but they work for an outside firm. And each of these contracts can run into the millions of dollars, yet the court does not have the same contracting obligations under federal law that other parts of the government do. In the interest of transparency, would the court consider publicly listing any contract that it has with an outside firm, security or otherwise, whose annual value is greater than $1 million?
I think we have, Justice Barrett and I have not considered that question or addressed that question, so I think we would need to go back and take it to people who have thought about that issue more.
Okay. All right, but let me switch to another more policy-driven concern. As of July 10th of this year, 75% of President Trump's appointees to the circuit and district court judgeships over the combined course of his first term and the current term have been men. Additionally, 84% of the appointees have been white, male or female. And when looking across all of the active circuit and district court judges as of July 10th, regardless of which president appointed them, nearly 60% are men. Additionally, 66% are white. Can you both speak to the importance of having a diverse federal bench that's representative of the country's demographics? And might you also add the experiential and other diversity for the courts itself, for the court itself, in your choice of your clerk pool?
Well, I'll take the clerk pool, if that's okay. We all run our chambers differently, and each of us hires for himself or herself, and so I can really only speak for myself on this. I value diversity of all kinds. I value diversity along the lines that you mentioned. I value diversity in terms of backgrounds and views, and to make sure that I get all different kinds of backgrounds and experiences when I'm talking with my clerks, in particular. And I've found over the years that that's perfectly possible to do. The standards for a Supreme Court clerk are very high. It requires outstanding law school records. It requires 2 prior clerkships, usually maybe 1, and judges who think very highly of the person. Sometimes now we're looking at people who have worked in other jobs before they come here, and we still have more qualified people, more exceptionally qualified people than any of us are able to take. And I find over time that that it's good to have diversity of background and experience, and that is very possible to do given our applicant pool now.
Thank you. Very quickly, I'm told that most of the justices and their clerks read your briefs electronically. So I just want to ask why the court requires the litigants to print and to file 40 copies of their briefs in most instances, which can sometimes cost them up to $10,000. Is there are there basis for income-based waivers, and doesn't the printing requirement now seem to be unnecessary?
We do have,
Go ahead.
I don't know. We do have informa pauperis status, which helps indigent litigants. I will say that some of us do read hard copies. I am old school in that respect. But I think those questions are ones that the clerk's office works out to help those who cannot afford.
Thank you. Now the chair recognizes the vice chair of this committee, Mr. Lalota, for his 5 minutes.
Thank you, Chairman. Justice, it's good to see you. It was good to see you on March 5th at the court, and we appreciate you being here today. Justice Kagan, thank you for your warm comments on Senator Graham. I, like many Americans, watched your interaction with him during your confirmation hearing. It was a good moment of bipartisan candor, one that we don't have enough of in this town, and I want to say thanks for not only that exchange, but for your opening remarks that addressed his commitment to service to our great country. I want to discuss some of the budget requests, and you're asking for $89 million for security, including 24/7 protection, additional protective personnel, and cybersecurity enhancements. Justice Barrett, can you briefly and broadly express how the change in the threat environment has necessitated that higher level of investment by the Congress?
I think it's because, when I was a law clerk, Justice Scalia did not have protection all the time. Justice Kagan mentioned she didn't have it when she began, but now the threats are constant and they're always there. And so it's necessary now in daily activities. Unfortunately, I honestly feel like if for the sake of my privacy, I wish it weren't so. But it's necessary for protection in daily activities to have a security detail. And frankly, our detail, one reason for our longer term plan to increase the size of our details to come closer to cabinet level officials is burnout and exhaustion. A detail of 4 to 8 people, when they have to monitor you around the clock, when they drop me off, I think I might have been mentioning this in our meeting on March 5th, when they drop me off at 11 o'clock at night, and then it's the same team that has to come back the next morning. I mean, it's just a lot of hours.
Thank you. Your feedback then and now is very instructive for this.
May I add just a bit?
Of course.
This began in part because of Congress, and it began in about 2016, I think, was when Justice Scalia died, and he died in a place in Texas, and there were no security people in the immediate area. I think the nearest were a couple of hours away, the nearest marshals. And we're very grateful because Congressman Issa and Congressman Cummings came to visit the court, and they were doing an investigation, you mentioned, of the Secret Service, and they were doing one at the time. And that required that they look at different institutions and departments, security personnel. And they came over to the court and they said to the Chief Justice, this was how the Chief described it to us. They said, kind of like, we think you're crazy, that you have less security than the director of the Office of Personnel Management does. And we think that you have to do better. And that was really the start when Congressman Issa and Congressman Cummings came to the Chief Justice, and the Chief Justice reported to us. And we were a little bit like, do we really? Because it's easier living life without security than living life with security. But we started, and we started slowly, incrementally, carefully, making sure that we balanced all the necessary factors. Then, of course, the Dobbs leak happened, and that really increased the urgency of the entire thing. But we've been working on this now for about a decade, and actually, I think, are grateful to Congress for coming to us and saying you have to up your game in this area.
And there's still more work to do in this area. I think that both sides of the aisle take your security seriously. Justice Kagan, you mentioned earlier in your testimony the wanting to decrease your reliance on the U.S. Marshals and increase your reliance on your own court police. Can you describe the impetus behind that dichotomy?
Yeah, nothing against the U.S. Marshals who do a terrific job. But I think this allows us to whenever we have to make a policy decision about how to use our security personnel, it's our policy decision. We don't have to convince anybody else. And what several members have suggested, I think, is absolutely true, that you want a completely stable workforce, so people who are providing you with security really know you And to the extent that we're relying on the Marshal Service, they're coming, they're going, they have other responsibilities. They probably won't be committed to an individual justice or to the court full-time.
I think I agree with your point. You should have a separation of powers in your own autonomy and your own security, and we should want to empower you to do that. Very briefly, in the world of finite budgeting, as you do more of one thing, you by necessity often do less of one thing, and we're right to consider doing more with respect to your security. Are we missing something when we do that? Are we doing something less when we do more with security? Are you doing less work? Are you delivering less opinions? Are we somehow degrading your ability to deliver justice in other areas?
I think we carefully steward our resources, and I think our budget reflects the needs that we have to continue fulfilling our constitutional mission.
Thank you. Appreciate you being here. I yield back, Mr. Chairman.
Thank you, sir. And now we recognize like the wedding feast at Kagan. We saved the best for last in our Cardinal Womack,
Thank you. Thank you, Mr. Chairman.
former head of this committee.
And what a joy it is to have our justices in front of us this morning. I've been around these precincts for a while now. I remember back in the day when it was Justice Kennedy and Justice Breyer that were here. You two have done very well today, but not quite as entertaining as those two guys. I can promise you that. And let me also acknowledge a couple of familiar faces in the crowd, Judge Dow, George Everly, who is back at the court now, and the great work that they do. We've had terrific relationships down through the years, and that has not changed with the court. And so I commend you for that and for this front row of people who obviously are your support staff and help this court continue its important mission. I don't have any budget-related questions, but in my remaining time, I'm going to give you an opportunity to speak to the rest of the people in this room. When I came in, and I came in late this morning, there was a line of people outside this door, and I'm sure that line is probably still there. And I was taken aback by how young these people look. So if you look beyond the front row in this room this morning, you will see the faces of young people from all walks of life who all to me look like they're at least under 25 years of age. And they are driven here for different reasons. I'm going to give you both an opportunity in the remaining time I have, 3 minutes, to speak to the hearts and minds of these young people who one day could be sitting exactly where you're sitting today, and give them hope that what we do in this country is, and what you do in the court is part of our genius as a country. And Justice Kagan, I'm going to let you go first. You have these young people's complete attention.
You're raising the bar here. Thank you so much, Congressman Womack, for that wonderful opportunity. I think I would say to the young people in this audience and the young people everywhere, what is just true of our democracy, that it rests in their hands. And how we function as a country going forward is in large measure up to them. And that they should take all the opportunities that they can to learn about our country and to learn about its history and to learn about our governmental institutions, and then to figure out how they can do better and leave the world a better place than they found it. And I think that I am optimistic that this generation of people will do just that.
Justice Barrett.
Hear, hear. I agree with everything Justice Kagan said, and I would add that I am heartened that so many young people are here and waiting in the line to want to see this hearing, because I think it shows engagement in our democratic process, and I think what they have seen is a really constructive bipartisan effort in this hearing to address these issues, and I hope they see that in the court's work. We work hard to, disagree well when we disagree, and we agree a lot of the time. And I think that kind of constructive engagement and not just throwing your hands up and saying, I'm not going to deal with people with whom I disagree, is what we need to move forward.
Great advice. Thank you for the great courtesies you've extended. Yes, Seems to me that's a 9-0 decision.
That's a 9-0, and that's pretty rare, but that's a 9-0 decision. Thank you for the many courtesies you and your teams have extended to my office and to this committee, and we respect the work of the court and continued best wishes. I yield
Thank
back.
you.
I will admit that Judge Dow is getting off awfully easy today, but that's for another day. The ranking member of the full committee has asked for a moment to address something that she didn't get to in her statement.
Thank you very much, Mr. Chairman, and I want to say to Mr. Womack, which is a very, the gravitas of what you've asked and the responses are really heartening and should be to all of us, and mostly including our young people who are today, who are hungry to be engaged and involved. My question goes back to something I was talking about, and Justice Kagan, it was just a couple of years ago. This has to do with the, you said the Supreme Court should consider an independent enforcement mechanism for its ethics code involving a panel of respected federal judges. Do you still support that?
You know, I personally do. I think that we would be better off with an enforcement mechanism. And I think, you know, it's not to say, I think that my colleagues are taking this code incredibly seriously.
Yeah, I understand.
We are all, you know, making every effort, and I think successful efforts to live by it. But if nothing else, for public confidence's sake.
Right, for the integrity
and
of the
also,
court.
an enforcement mechanism can, you know, also make clear that not every accusation, not every charge has anything to it, and can make clear this is off base, this is wrong, there's nothing here. But I think that it would be a good thing to do. As you say, I think it's really important that it come from the judiciary itself. There are real complexities about how that would be done, but I have not changed my mind.
And Justice Barrett, do you support that effort?
I'm less certain. I mean, I'm certainly fully committed to the code, as are all of our colleagues, but because of some of the complexities that Justice Kagan identified, I'm just not quite sure. The judiciary moves slowly, the court moves slowly, we have turtles everywhere because of that, and I think that if we had a body to enforce the code, it would have to come from within the judiciary.
Yes, without
and I just think
question.
that it's a question of who selects the judges, how is the panel comprised? There are just a lot of complexities.
Well, there's lots of integrity with regard to the court, there's no doubt about that. But a mechanism, every other body has that. We have a committee, all the federal courts do. It's just the Supreme Court that doesn't, and it should come from the judiciary. And my hope is that that be for the integrity of the court. We're all under real fire these days, and that includes the court. I think we have to demonstrate at every turn that we are understanding that of the kind of morality that we need to have and that we need to demonstrate to the public about how important we take the roles that we have and that we're not somehow abridging the system or abusing the system. Thank you very, very much, Mr.
With that, our time has concluded. I would like to thank both Justice Kagan and Justice Coney Barrett for their being here today and for your answers. There may be some members of this panel who would also like to submit questions for the record. Please submit any questions for the record to the subcommittee staff within 7 days. This subcommittee stands adjourned.
By thanking you for reaching out to have a dialogue with me, and I look forward to making that happen. Also, I certainly appreciate your response, particularly to Congressman Meeks and Congressman Foster, on you holding firm on independence and that you would protect the data and the law. That goes a long way with me. I want to start with a question about the housing market. As you're aware, the Federal Reserve monetary policy heavily influences the United States housing market through setting of benchmark interest rates that directly dictate the mortgage rates and housing affordability. Many homeowners were able to access mortgages at historically low interest rates during the pandemic, but rates have more than doubled since then, and I'm concerned about the impact this is having on first-time home buyers and minority borrowers in particular, who are also facing high home rates and insurance policies. Homeowners are exiting pandemic-related forbearances and also are struggling to enter into affordable repayment plans due to the high interest rates, which in many cases could push them into foreclosures. Now, I understand that the Fed can't increase housing supply or prevent foreclosures directly, but I'm interested to hear your thoughts on the impact of rate hikes on the housing market, especially for those more vulnerable homebuyers. And certainly, you know, we have a new amazing housing bill, the 21st century. I have to get that plug in, that I have 6 bills in that. So now I yield to you.
Thank you, Congressman. We stay out of housing policy, and as the debate that's been had in this room suggests, you all have a lot to say about what housing policy is going to be, but I don't want to suggest that we don't touch it. We don't target housing, we don't target any particular sector, but the decisions we make have a big effect on housing. Yes. And housing plays a huge role in most households' family budgets, in their savings. So we recognize the importance of it.
And rate hikes. Correct.
Absolutely. We, as I said in my opening statement, I think broadly about the conduct of policy today. I sounded quite optimistic about what was happening in manufacturing, what was happening in output. But you heard me say a somewhat more cautious note about housing. And I think that's in part because monetary policy, when rates were cut to extremely low levels, provided what was thought of as a once-in-a-lifetime opportunity to get the first house. I would prefer a set of monetary policies that are not boom and bust, that don't just make one generation more fortunate about being able to afford their first home than the next. So what we can do in monetary policy is try to be clear about our objectives, deliver price stability in the context of full employment, and not react overtly to any data that happens one day or the next.
But
we have an effect on long-term rates, and we take it very seriously.
And you'll be sensitive to the issues that I'm bringing up. Okay, in my last minute, let me now turn to fraud and scams, which is one of the top concerns that we've been dealing with lately in this committee and my subcommittee. As you know, payment frauds, including scams, often involve multiple institution and payment methods, and no single agency or entity can solve it alone. What specific role do you believe the Fed Reserve should play in helping build a more coordinated cross-sector approach to frauds and scams?
Yeah, so it's another fair one. The Financial Stability Oversight Council, which the Fed is a key member of, fraud is on that agenda. That committee is run by the Treasury Secretary under the law, but the Fed has equities there, and the Fed needs to ensure that, especially with this new generation of technologies, that the American people don't lose confidence in our payment system, don't lose confidence in the banking sector that we regulate. So we do have an important role to play there as well.
I'm gonna interrupt only because I have a few seconds later. I'm glad you mentioned this new generation. I've received feedback that better information sharing between financial institutions and online platforms is key. Do you agree?
Absolutely. Real-time information between lender and borrower is a way to make credit more available to more hardworking Americans.
Thank you, and I yield back.
Gentlewoman yields back. The chair recognizes the gentleman from Tennessee, Mr. Rose. You're recognized for 5 minutes.
Thank you, Chairman Hill, and thanks to Ranking Member Waters for holding the important hearing. And Chair Walsh, thank you for being here with us today. Chairman Walsh, Prices for agricultural inputs have, after experiencing a spike during the Biden inflation that began in 2021, have remained stubbornly high. Needless to say, families are also in my district were themselves hit by the rise in food prices that began under Biden and your predecessor in 2021. And grocery prices remain persistently high. This strains household budgets and makes it harder for people in my district to put food on the table while also paying for all of life's other necessities that are also more expensive following that inflationary period. We saw in the 1980s how hard it is to deal with persistent inflated prices and the difficult decisions it can place on the Fed to get and keep them under control. Can you please tell us what is the Fed doing and what do you intend to do to ensure that a resurgence of inflation does not materialize?
So that's job number one. We cannot, I don't want to overstate, we cannot have a direct, immediate effect on short-term particular prices at the grocery store or in agricultural goods. But the job you gave us, and the job we are resolute about accomplishing, is to make sure that any short-term changes in particular prices don't broaden out, don't change to a generalized change in the price level. Unfortunately, that's what's happened for the last 63 months, and those days have to be a thing of the past. I'll make one other note. Good economics, going back a couple of generations, talks about sticky prices. And the longer that prices have been above the inflation target, it's usually a bit harder to dislodge them and get them lower. Our job, my commitment to you, is to take sticky prices and to unstick them.
Thank you. I agree wholeheartedly with that sentiment, so I thank you for your perspective. The Fed made some interesting judgment calls during the last administration when it came to its supervision and regulation decisions. Whether it was the war on digital assets, the crusade to make the Fed a climate regulator, or the use of reputation risk to debank disfavored firms and individuals, the Fed allowed itself to become the instrument of partisan actors pursuing goals beyond the powers that Congress has authorized. The Fed needs to stay in the lane that Congress has handed it and not veer off course whenever political winds shift. When the Fed does the latter, it undermines its standing in the eyes of Congress and the American people. Chairman, will you commit to getting the Fed back to truly sticking to its lane? And if so, how do you plan to do it?
So I can make that very commitment. Our credibility in monetary policy, our credibility as supervisors, our credibility in payments, these are all tied together. And the way we erode that credibility are two things. We wander outside of our lane into your lane or into the lane of another executive branch, or we don't deliver on our promises. The first thing we can do is to deliver on our promises, and the second thing is, as you said more eloquently than I did, stick in our lane. That's what we're going to do.
Thank you again. Both the G7 and the administration have issued statements or executive orders on quantum computing, encouraging financial authorities and U.S. federal agencies to step up their timetable for transitioning to post-quantum computing encryption algorithms. With just a few years until experts warned that quantum computers could break widely used encryption algorithms, what is the Fed doing to address this future risk?
Yeah, so like you, Congressman, it's a future risk. Since I graduated from college more than 30 years ago, quantum computing was always just a few years away. I hope we're there this time because like in artificial intelligence, I think the United States can be a huge beneficiary. But like with AI, there's risks. I've spent quite a bit of time in my 7 short weeks at the Fed thinking about our vulnerabilities as an institution, thinking about if bad actors were to take technologies that are now at the frontier or might be with quantum in a few years and try to pressure us to do harm to the perception of the U.S. or the Federal Reserve and the system. So we need to harden our technologies. We've got an enormous amount of talent at the Fed. The world's moving faster, and we've got to move fast with it.
Thank you, Chairman Warsh. I see my time is about to expire, so, Mr. Chairman, I yield back.
Gentleman yields back. The chair recognizes the ranking member of our task force on monetary policy, Mr. Vargas, California. You're recognized for 5 minutes.
Thank you very much, Mr. Chairman, and thank the ranking member. Of course, I want to thank you, of course, Marcia, I appreciate, like everybody else, the communications that we had, and I want to be honest with you that I wish you the best success. I really do. Thank you. I think if you're successful, I think the Fed will be successful, and if the Fed's successful, I think our economy will be successful. If our economy is successful, I think the American people benefit. So I'm one of the ones cheering for you, and I hope the best for you. Now, I have to say, though, I'm glad we're not litigating the past, though it seems that a lot of my colleagues like to. They talk about the past chair and some of the things that the previous president said, so I'm not going to litigate, but I would remind them that they passed their big ugly bill and put trillions of dollars in the deficit and the debt, and they seem to forget that, so there's a little bit of amnesia there. They remember some things well, but they forget others. Now, one of the things that I have sort of strange in my background, or maybe not, I studied to be a Catholic priest for a long time. I was a Jesuit. And they make you do things that are kind of odd when you're starting off as a novice. One of the things they made me do is to take communion to people who were sick. And they would do it as an experiment to test you and to do different things. I remember one person very clearly. He was a man who had been blinded, I should say, at World War II. Wonderful guy. Lived in the Santa Barbara area. And I'd take communion to him. I had to sit there and listen to him for a long time. And he would just talk and talk and talk, and I'm thinking, I'm not getting anything out of this other. I'm sitting with this guy, which is fine. And I finally started listening to him, and I actually learned a whole lot from him. I understood why my novice master had sent me there. And one of the things he said was really interesting. I never forgot that. I said, yeah, people march around, and yeah, they look pretty in their uniforms, but you never know how a person's going to react until they're under fire. And the reason I say that is, you kind of mentioned it too. In ordinary times, it's easy. When the crisis hits, that's when the issue is. That's why if you litigate the past, yeah, okay, you can litigate the past, but the truth of the matter is things happened. The Great Depression, things happened. We were, so blindly stuck on the gold standard and other things. And of course, we talk about the great wealth that the dot-com did. Well, I remember the dot-com bust too. $5 trillion disappeared just like that. And then of course you talked about the 2008 crisis when you were here. And all of a sudden there you had, the government working together, the Fed chair and the Secretary of Treasury had to, because the economy was melting down. Now, I don't wish any of that upon you, but the truth is that you could get that. You could get an AI collapse. I mean, the Magnificent Seven have really driven the market tremendously, and sure, there's great opportunities, and I hope that it is successful. But if it's not, then I hope that you also have the flexibility to figure things out. I mean, my colleagues love to talk about, what Chairman Powell did. They seem to forget that there was a pandemic and that we could have been slipping into a depression if we hadn't done some of the things. They seem to forget, too, the person who closed down the government was actually, in the economy, was actually President Trump. It wasn't Biden. Everybody blames it on Biden. When I was here, it was Trump that did that. The decision he made, I don't know if it was good or bad, but it was the decision he made under fire. So anyway, I wish you the best, but I do want to ask you about that. What happens when, as they say, it all hits the fan? How will you react? Will you react in a way that's flexible, or will you react in a way that almost seems today almost robotic?
Well, I appreciate it. I take that as a blessing that my 4 years will be ones of calm and peace and price stability and full employment. So I take it in the way it was granted. But we have to be prepared for shocks that are unanticipated. We have to be open-minded to things that might happen. So while it might not be common for the economics profession, we have to show a lot of imagination. My general view, again, coming out of the 2008 crisis, is we need to think ex ante about what we might do when the shocks happen. And it'd be okay to share with the world how we're buying insurance, how we're trying to protect the resiliency of the Fed systems, how we want the banking system, if times aren't always perfect, to be strong and resilient and competitive. And in the conduct of monetary policy, we want to anchor stable prices, deliver full employment, so if and when the shock happens, we have rebuilt the credibility that may have been somewhat lost in 63 months of higher prices. I am not relitigating the past. I know my colleagues have been trying to deliver on stable prices and full employment for a long time.
My time is up. The only
and
thing
I intend
I'd
to
say
do so too.
They were honorable people, and I think they did the best they could, and I hope you do too. I know you're an honorable person. Good luck, sir.
Gentleman yields back. Chair recognizes the Chair of the House Small Business Committee, Mr. Williams of Texas, for 5 minutes.
Thank you, Mr. Chairman, and also, Chairman, congratulations to you. America's banking system is the engine of prosperity in this country, and it plays a critical role in creating opportunities. From the community banks that serve small towns and Main Street businesses to the larger institutions that support our capital markets, access to credit is essential for families, entrepreneurs, and job creators. And as a businessman who has owned and operated a small business for 57 years, I know firsthand how important it is to have a banking system that is both safe and accessible. And the American public and the American people expect a chance to pursue their American dream, and access to affordable credit is often what makes that possible. So under the Biden administration, we saw proposed regulations that threaten that dream by making credit more expensive and harder to obtain. So my question would be, can you tell us how you think the Federal Reserve's supervisory role can promote a safe and sound banking system while ensuring businesses and families continue to have access to the credit they need to pursue the American dream?
It's a great question, Congressman. I'd say two broad things. One is we need a highly competitive, diversified banking system. This is the secret, one of the unheralded secrets of the U.S. economy. Our banking system is larger. The number of institutions of various sizes serve different constituencies. I think part of the reason why the U.S. has grown faster than our G7 and G20 colleagues is because the banking system here is fundamentally different. Secondly, what I would say about how we do that is we need to have tailored regulation that befits the kind of institution and the customers that they're treating. One size does not fit all. And finally, I'd say I am all for international coordination of banking standards. It is a useful effort so that we meet in Basel to try to come to some international standards. But the Basel endgame is not America's endgame. That is not the Federal Reserve's endgame. Our endgame is ensuring that we have the right rules that befits our economy so that we have a safe, sound, and competitive banking system. And anything we agree on with international counterparts have to be in service of the American economy.
Thank you. And as businesses depend on clear, consistent rules, when Congress passes a law, it reflects the will of the American people. And agencies like the Federal Reserve have a responsibility to faithfully carry out those laws, and regulatory certainty gives businesses like mine the confidence to invest, hire, and grow. So question would be, can you tell us how you intend to guide the Federal Reserve, and will you commit to ensuring the Fed carries out the laws of Congress that Congress passes without expanding beyond its statutory authority?
Yeah, I can make that commitment to you, Congressman, because that's how we keep politics out. That's how we stay independent in the conduct of monetary policy. The Federal Reserve is not a repair shop for broken statutes, or we aren't empowered to go wander into areas outside of our remit. We've got a big and important job, I understand it, but it's bounded, and we have to stay inside of those bounds.
My last question real quick, Chairman. One lesson I've learned in business is that your word matters, and when you make a commitment, people expect you to follow through, and consumers' trust is earned by doing what they say you are going to do. So the Federal Open Market Committee has made a commitment to the American people to restore price stability. Families and small businesses across the country are trying to plan for the future, and they're counting on the Federal Reserve to deliver. So, Mr. Chairman, in the short time we have, what is your strategy for restoring price stability, and what confidence can you give the American people that the Federal Reserve will achieve its price stability target?
So I can give you the commitment that we will deliver price stability. I was comforted at my very first meeting about a month ago. As I looked around the table of my 18 colleagues, there was no willingness to tolerate higher prices. There was a commitment that was unambiguous and unanimous that we're going to deliver. So the next question is, how are we going to deliver it? First is, I would say, make it very clear to you and the American people and to U.S. businesses that that is not a commitment we're going to walk away from, and we're not finding acceptable the higher inflation that has endured in this country for more than 5 years. The second thing that we're going to do is take responsibility. As I mentioned to one of your colleagues before, in our view, in my view, there is no anguish in central banking. This isn't saying, oh, I wish this or that were to happen. You gave us a lot of the tools to deliver on that commitment. We intend to do it. And the third and final thing I'll say is we have the tools to do it. We have a printing press. We have a balance sheet and interest rates. They have both provided significant accommodation and restrictiveness during different parts of the business cycle. And over the coming period, I'm going to ask our colleagues and have a good family fight about the extent and timing in which we would need to deploy those
Gentleman's
to
time
deliver
has
on the
expired.
promise.
Appreciate your leadership. I yield back.
Chair recognizes the gentleman from New Jersey, Mr. Gottheimer. You're recognized for 5 minutes.
Thank you, Mr. Chairman. Chairman Walsh, congratulations again, and thank you for your service to our country.
Thank you.
You stated that the use of AI technologies is, quote, a paradigm shift, and that the United States would be, quote, a big winner in the medium term. How has the use of AI impacted your view and the future of the global economy, and how is the Fed reacting? How should it react, and especially vis-a-vis China and our other competitors?
So I don't view the U.S. economy as in a zero-sum game. I don't think that weakness abroad is good for the U.S. But what I do mean to say is if there was one thing that is the biggest driver of American prosperity, it's productivity. Productivity gives companies the ability to invest in new capital. Workers then have that new capital and can deliver and ultimately have higher real take-home wages. This is a supply shock in the United States. I have to admit it's happening faster than I would have projected 18 months or 2 years ago. We're seeing this technology and the capability of these models grow at exponential rates. Something like a hyper Moore's Law is happening. I don't want to suggest that we know exactly how this is going to shake out, but the U.S. is best positioned to be a winner. But again, as I may have mentioned earlier, you gave us a job to deliver stable prices and full employment. What are the consequences? What are the implications of this positive technology shock to that? I've taken 3 experts. I've asked them to deliver their views to us over the coming 3 to 6 months. And then internally at the Fed, we're going to do a lot of work. I'm confident that at the end of the day, the U.S. is a winner, but it's not going to be a linear path, and I'm open-minded to challenges both to the full employment and price stability part of our mandate.
Right, because as part of that, I assume the workforce employment is going to be, what should our goals be? Should they shift? I assume those are the kind of questions you all are debating?
Yeah, we're debating just those questions, Congressman, and if I were to look over the last few months, it looks to me as though this technology hasn't displaced workers at this point. It's made them a bit more productive. And I say a bit because I think the productivity is in front of us. But a year or 2 from now, will these intelligence tokens be adding to the workforce or causing the workforce to temporarily be disrupted? That's something that we're very focused on as we think about what the economy looks like 12 and 18 months from now.
Thank you. We're seeing an unprecedented number of children using apps on their phones like prediction markets or sports books to gamble. Research is showing especially young people are very active in the past year. 11 to 17 have gambled in the last year, 36% of them. What is your view regarding possible insider trading on these markets? Are you thinking about that? Do you think we should be doing more to protect our children on these betting apps? Have you thought about that at all?
Well, I've thought about in 2 respects. First, when I was sort of a junior in junior high school and high school, I was the nerdiest kid probably in this room, so I wasn't wandering into those.
That's saying a lot. You should meet the chairman. Yeah. Go ahead.
But generally, the questions about the use of kids and smartphones and whether insider trading is happening and the rest, that is almost entirely outside of the Fed's jurisdiction. So I'll defer to other people around, both in the Congress and the executive branch, to take those on. I don't really have much more for you.
Let's pivot to something else. Modernizing and expanding certain aspects of the federal deposit insurance remains an important priority for me. Will help ensure that small businesses remain stable and mainstream is able to thrive. What are your thoughts on mandated federal deposit insurance standards across the board for all banks? Should there be specific asset thresholds, a tiered system? Is there a middle ground in this debate?
Yeah, so we're going to follow the law, and we're not going to weigh in on what we think the right deposit insurance caps are. But I don't want to walk away from the question entirely. The FDIC insurance caps should be binding. That is, we need to have a supervisory and regulatory system such that if a few banks get in trouble, either myself or the Treasury Secretary don't have to, in unusual and exigent circumstances, provide backstops for everybody, including depositors. So the way I think about it is deposit insurance reform and proper deposit caps should be of a piece with strong reform-oriented supervision and regulation. So the law that you decide should be the right caps for individual deposits. That should be the case both in good times and bad.
Last question. Do you think that people in my district, young people, keep coming up to me and say they're not going to be able to afford a home, to be able to get a mortgage? Do you feel confident in your tenure people are going to still be able to afford to get a mortgage?
I'm a great believer in the American dream, and I know that a mortgage and first-time house is one important step to do that, and we'll do what we can to support it.
Thank you. I yield back. Thank you. Congratulations again.
Thank you, Congressman.
Gentleman yields back. Chair also wants to, as I call on the gentleman from South Carolina, just offer condolences to the gentleman from South Carolina and all the people of South Carolina on the loss of Senator Graham. And with that, the chair recognizes the gentleman from South Carolina, Mr. Timmons, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Chairman Warsh, for appearing before the committee today. The Federal Reserve has an important responsibility to carry out the mission Congress assigned to it. Maintaining public confidence depends not only on sound economic policy, but also on staying within the statutory mandate. In recent years, many Americans question whether the Federal Reserve moved beyond that mission through actions involving climate-related financial regulation, digital assets, and reputational risk. I appreciate the steps that have been taken to refocus the institution on its core responsibilities. Looking ahead, it is important to ensure the Federal Reserve remains focused on the responsibilities Congress has given it. Chairman Warsh, what steps will you take to ensure that the Federal Reserve remains faithful to its statutory mandate and develops institutional guardrails that prevent future departures into area beyond the authority Congress has delegated?
So this is no time to wander, Congressman. The job you gave us that's clearly in the four walls of our authority in monetary policy and payments and supervision and regulation, we're early in a reform agenda. All of our assets, all of our resources, the remarkable talent of my colleagues need to be focused there. Good intentions are not enough, and it is not the culture of the Fed or the best of the Fed's traditions to wander into areas that are not our responsibility. And when we do, we sacrifice the credibility we need to accomplish our core tasks.
Thank you for that. More broadly, the issue of mission creep has challenged many federal agencies over time, and the Federal Reserve has not been immune. Following the financial crisis of 2008, the Federal Reserve assumed an increasingly expansive role through extraordinary monetary interventions. More recently, the institution became involved in matters such as climate-related financial supervision, digital asset regulation, and the application of reputational risk in bank supervision, leading many to question whether these activities extended beyond the responsibilities Congress intended the Federal Reserve to perform. Mission creep carries meaningful institutional cost. It diverts resources from core responsibilities, exposes agency actions to legal uncertainty, and risks undermining the Federal Reserve's credibility as an independent institution that derives its authority from Congress rather than from evolving policy preferences. A central bank is strongest when it exercises the authority Congress has granted with discipline and restraint. So, Chairman Warsh, as chairman, what principles will guide your efforts to ensure that the Federal Reserve remains focused on its statutory responsibilities and resists institutional pressures to expand beyond the role Congress has assigned?
The most important thing at the Federal Reserve, as I mentioned before, is not the printing press, it's our culture. And the best of the Fed's traditions tell us what our culture should be: accountability, responsibility, and performance. By reiterating that, by reminding all of our colleagues that that's what drives us, I've started to do it in my first 7 weeks, but it's resonating. I hear it back in the hallways. I hear it at the cafeteria. And so at some level, people might think of this job as getting the answer right, well to the right of the decimal point, and occasionally we do have to wander there. But in order to deliver on what you've asked us to do, I've always thought that most of this job is the left of the decimal point. We're going to get the culture right, we're going to get the strategy right, we're going to get policy right, and we're going to get the organization right. And if we can do those big things, getting the right answer to the right of the decimal point, I think will be a lot easier.
Thank you for that. I would also like to discuss inflation because maintaining price stability remains one of the Federal Reserve's most important responsibilities. American families have experienced the highest inflation in more than 4 decades. Rising prices reduce purchasing power and place real restraint on household budgets. While inflation has come down from its peak, recent data suggests that inflationary pressures remain and price stability has not yet been fully restored. The people I represent should not have to endure another sustained period of elevated inflation. Stable prices are fundamental to long-term economic growth, household financial security, and confidence in our monetary system. Chairman Warsh, what is your assessment of the current inflation outlook, and what policies will the Federal Reserve pursue to ensure that restoring and maintaining price stability remains its foremost monetary policy objective?
First, I agree, Congressman, with your diagnosis. For too long, American households and businesses have suffered the undue hardship of high inflation. This Fed will deliver price stability. This Fed has the power to do it. We have the tools to do it. What I would also say is I'm not in the business of trying to prejudge what the committee that I'm honored to lead decides. I think we need to have a continued good family fights on this subject. That'll start again in a couple of weeks. And when we have news for you about exactly the methods of solving this problem, we'll be very clear about what they are, and so will the American people, to deliver price stability.
Thank you. I yield back, Mr. Chairman.
Gentleman yields back. The chair recognizes the gentlewoman from Massachusetts. Ms. Presley, you're recognized for 5 minutes.
Thank you, Mr. Chair, and welcome, Chair Warsh. Congratulations, and welcome to the Financial Services Committee. I represent the Massachusetts 7th Congressional District, a beautiful, dynamic district, and also one that is deeply unequal. In fact, in a 3-mile radius from Cambridge, home to your alma mater, to Roxbury, a historically Black, vibrant community in my district. That being said, median household income drops by $50,000 and life expectancy by 30 years. That's just in a 3-mile radius. And those inequities are not naturally occurring. They are man-made. They're the result of intentional and deliberate government action. So I'm here, and what guides me is the work to be just as intentional and just as deliberate in making sure that government works for all people. And I know we're just getting to know one another, but I hope I can count on your partnership in that mission, Mr. Chair. I'm going to begin with what should be an easy yes or no question. Are you committed to fulfilling the maximum employment requirement of the Federal Reserve's statutory mandate?
Congressman, absolutely. We have no disfavored part of the job that you gave us. Price stability and maximum employment are not an either-or proposition. I'm committed to both of them.
Well, that was my next question, if you viewed this mandate as equally important as the price stability mandate. Now, since Trump took office, hundreds of thousands of people have been pushed out of the federal workforce. The current unemployment rate is 4.2%, which is higher than when Biden left office. And if you look deeper into the data, Black unemployment writ large is at 6.6%. Now, the Federal Reserve semi-annual report highlights that Black people have continued to have higher unemployment rates and lower wages than white workers. This is a problem. Now, it's a problem for Black workers, it's a problem for the Black family, but it's a problem for everyone. It's a problem for workers like Teresa in my district, who despite being educated, qualified, and good at her job, was let go from her public health position due to government funding cuts. And with the state of HHS, our country needs to employ all of the public health experts that we can find. But this is also a problem for our national economy and financial stability. Let me illustrate what I mean. According to one report, Black Americans held a buying power of $1.6 trillion in 2020. Economists estimate that 2% of Black women being fired has led to $37 billion being lost in GDP spending. So when that money is lost, it impacts everyone. It impacts our small businesses that spur local economies and workforces. So the point is, when Black workers lose, everyone loses. So Chair Walsh, given the persistent racial disparities in unemployment, will you, as Federal Reserve Chair, commit to confronting these workforce challenges that Black workers are forced to endure?
So, Congresswoman, I'll say this, which is the U.S. can ill afford to leave any individuals behind. the economic opportunity, which is essential for America's growth trajectory over the next 5 and 10 years, means that every American needs to have opportunities to be productive. And I believe, unlike some in the economics profession, that productivity-led economic growth is a good thing, not a bad thing.
Thank you, Mr.
And
Chairman.
I'm hopeful that the Fed, we can be supportive of opportunities for economic growth.
And I want to say specifically for black workers, because of a problem of this magnitude, there are 700,000 unemployed black women right now. If a problem of that magnitude was happening to any other group, we would do the analysis and we would have a plan. So I'm going to ask of you what I asked of your predecessor, for you to come and brief the Congressional Black Caucus on your strategies and efforts specifically to the black worker, given the disparate impact. You know, you've talked about your refusal to tolerate a persistent high inflation. I need the same rigor, the same vigor, and the same commitment when it comes to the black worker. It's already a part of your mandate.
So American workers, no matter their backgrounds, have my commitment to do what we can at the Federal Reserve to make sure they have all the opportunities in front of them, regardless of any characteristic.
Well, Mr. Chair, experts believe we need targeted structural efforts to address unemployment disparities. So I'm asking
Gentlewoman's
for
time has
focus.
expired, and
Okay.
invite the chairman to answer your question in writing, and thank you. Chair recognizes the chair of our Subcommittee on Oversight and Investigations, Mr. Muser of Pennsylvania. You're recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. We also appreciate very much yours and Vice Chair Bowman's work on fraud and scams. We have a report coming out next week from my subcommittee, which we'll be looking forward to sharing with you. As you know, CPI came out this morning. Well, underestimate, we could say. For all intents and purposes, the underlying economy is strong. The small businesses, community banks I speak to throughout, for the most part, throughout Pennsylvania, report steady demand and positive business outlooks. As well, the businesses are profitable. Tax revenues for the federal government are up 6.9% in 2026, which is phenomenal. In Pennsylvania, by the way, they're up 2.4% this last fiscal year, and they're glowing about that, raving about that. So federal revenues are way up, which shows businesses, again, are profitable. Many of us in this committee have made the case for quite a while now that the Fed needs to review the big picture, as you've been making commentary towards. Supply side growth and lower interest rates are not in conflict. They are, in fact, very often complementary. As lower interest rates encourage more cap investment, they can put downward pressure on inflation simply by using the well-known equation: when supply exceeds demand, prices go down. I'm glad you appreciate that very much. So, Mr. Chairman Walsh, you've created these task forces, which we're all pleased to see, I think. And will you express how these task forces will help achieve the Fed's goal of 2% inflation?
Thank you, Congressman. I'd be happy to. The 5 task forces are an attempt to go back to first principles. Ask whether the way the Fed has conducted business for more than a generation, the way we've gathered data, the way our models make forecasts about what's going to happen next, our understanding of changes in productivity and changes in the supply side. These are all big fundamental questions, and I think we are better equipped to make smarter decisions on policy so that we can deliver price stability and full employment if we get the benefit of some outside views. Again, we're going to then decide what to do with them. We're going to make the decisions. We're not going to outsource them. But if there was ever a reason after a long period of inflation that was too high to go back to first principles, this is it. And like you, while I reviewed the data that came out this morning on CPI, and it was positive relative to expectations, I'm not for cherry picking. I'm not going to show up here and say mission accomplished. And what I'd say is there's plenty of work to do, and I would feel more confident if we had better data to inform our decision making. We have a task force that's going to be focused on doing just that.
And I know you're also going to utilize the balance sheet process as well. You've critiqued the QE planning or activities for a while. You've stated you plan to reduce the Fed's balance sheet. How do you plan to do that, and what role does the private sector play?
On the balance sheet, again, I don't want to prejudge the conclusions of the task force, and I can't speak for 18 of my other colleagues. But as a first approximation, I'll say now what I've been thinking for years. In normal times, the Federal Reserve should be a price taker, not a price maker. We should be observing what is the price for a 10-year Treasury between a willing buyer and willing seller. We shouldn't have our thumb generally on the scale. Now, when it comes to a crisis, I don't want to suggest that we're going to be able to sit on the sidelines. I would hope we could, but I can't say that for sure. The Fed balance sheet, both its size and duration, are worthy of a very worthwhile review. I'm inclined to think that there are better regimes we can go to, but we're not going to do it without due consultation with the markets and with members of this committee.
Great, and certainly the reserve requirements of banks and all may put this in the hands more so of the private sector, as I think you believe. Chairman Greenspan in the 90s recognized that a productivity boom from computers and the internet was putting a downward pressure on inflation, and he cut rates based on that data, ahead of the data. Does AI present that same kind of opportunity today?
If you've seen one productivity boom, you've seen one productivity boom.
Okay.
I take very seriously the productivity booms that we've had. And generally, if you look at the surge in productivity in the post-war era in the United States, we tend to move from a relatively low productivity realm environment where productivity grows about 1.5% a year. And then for a decade or longer,
Gentleman's time has expired.
to a higher productivity realm. I think this could be that opportunity, but I can't say it for certain as of yet.
Thank you. I yield.
Chair recognizes the gentleman from Illinois, Mr. Caston, for 5 minutes.
Thank you, Mr. Chairman. Chair Warsh, nice to see you here. Welcome. I want to start with just a purely academic question for you, just on economic theory, but with some context. You talked to Dr. Foster about your experience in the 2008 downturn. I was not here in 2008, but I remember in 2020 when former Chair Bernanke came in as someone who had some experience steering through a crisis. I remember that we had this meeting in March of 2020 saying, we've never seen unemployment spike this quickly since the Great Depression. We've never seen GDP collapse this quickly since the Great Depression. And here's someone who steered the economy through an $800 billion bailout, which at the time seemed like a big number. I mention that, number one, because I hope you don't find yourself in the future being asked to address Congress based on your own expertise steering through through a crisis, although certainly Chair Powell got his chance there as well. But the difference in the way that we responded to COVID and the way we responded to 2008 was a much heavier fiscal stimulus, whereas the 2008 crisis was, largely QE and monetary, as big as $800 billion was. We also recovered from COVID a ton faster, not only faster than everybody expected, but faster than all of our peers. And should we find ourselves in another crisis, what do you, just as an economist, how do you think about the right shaping of fiscal and monetary policy? Obviously, you only have purview over one of those, but your voice is going to matter.
As I said in an analogy to one of your colleagues, I'll say it here. If you've seen one financial crisis, you've seen one financial crisis. So I'm careful about extrapolating. More generally, I would say the response to the 2020 pandemic had some very similar areas with respect to monetary policy. That is, the central bankers in 2020 took some of the toolkit that we innovated on in 2008 or 2009, and they provided overwhelming liquidity. That's in our remit in crises, not in more normal times. My judgment in 2008, judgment in 2020, and if we were to have a crisis when you and I are in these roles, I would be describing to you what the central bank can do. I would also try to describe to you the limits of our authority, such that you have the opportunity to make whatever decisions you think are right. But I'm going to make a promise to you now that I would hope to hold to then, which is the fiscal policy response is going to be the decision of you and the administration. We're going to do our very best to steer clear of that.
Well, and I appreciate that, and I think none of us want to go there again, but we also want to make sure that, monetary policy can target some sectors of our economy, not the others. We need to work together. On a similar subject, I want to pivot, and I was spinning through, and I love these reports all the time. Send them it's always good reading. I wanted to talk specifically about Figure 1 and Figure 43. Figure 1 shows U.S. CPI over the last decade or so. Figure 43 shows global CPI trends. And what's very clear is that U.S. inflation picks up immediately after Liberation Day on account of the tariffs. Global inflation picks up after the Iran war. You can see the spike. So, we had inflation generally coming down after 2020, starts picking up on account of tariff policy, and then starts picking up again on account of foreign policy in the United States. And you can just see in those charts what was domestic and what was international. How effective is monetary policy when it's fighting with fiscal policy or foreign policy or economic policy? Because I don't really understand the theory of the case that interest rates undo tariffs or that interest rates undo high oil prices, or for that matter, QE or the other things. So, how concerned should we be about monetary policy that's got a different set of goals than the outcomes of fiscal policy right now?
So generally, Congressman, I'd say a couple things. First, we are takers of the fiscal policy decisions that you and your colleagues make. We will take that into account. I'm not suggesting that we act in isolation. What I am
to be clear, we didn't vote on tariffs or the Iran war.
But the policies that are made of the executive branch and of Congress, we're aware of them. We have a wide lens, but we then take those on board and make whatever decisions we best can consistent with our remit.
Do you have the tools to counter them?
We have tools that are powerful. Whether they're working at cross purposes or consistent with them is never easy to know in real time. But let me make one other important distinction. Military conflicts overseas, changes in trade policy, changes in immigration policy, those have an effect and we can take them into account. Often they have an effect on prices in the short term.
Time has expired.
Our business is whether those prices in the short term end up spreading out, and that's our responsibility.
I'm out of time, but let's stay coordinated would be my request.
Chair recognizes the gentlewoman from California, Ms. Kim, who also chairs our Asia Pacific Subcommittee on House Foreign Affairs. You're recognized for 5 minutes.
Thank you, Chairman and Ranking Member, for hosting today's hearing. And Chairman Marsh, welcome. This, I understand, is your first appearance before our committee since your confirmation, so congratulations. Earlier this year, you may have heard I introduced Payments Access and Consumer Efficiency Act, PACE Act, with my Democratic colleague Sam Liccardo, because I kept hearing from my constituents in Orange, Riverside, and San Bernardino counties about how important these payment modernization is in helping small businesses owners make payroll and make sure that their workers get their paychecks on time. And President Trump understands that, which is why he issued the executive order earlier and signed that to call for a financial system that is more innovative and is affordable for American families and businesses. So Chairman Marsh, I understand you share that goals and vision for the Federal Reserve as well. But currently the situation is the payments company holding money transmitter licenses in all U.S. states and complying with every Bank Secrecy Act rule and holding customer funds in a one-to-one liquid reserve still has no legal pathways to access the Federal Reserve payments rail directly. So as a result, small businesses and consumers bear the burden of increased costs and slower payments. So the PACE Act is trying to address that by creating OCC supervised activity-based registration for sophisticated payment companies that trade federal safeguards, BSA compliance, and capital reserves for direct access to FedNow, FedWire, FedACH. So, Chairman, can you talk about how you plan to work with the OCC and Congress to ensure that well-regulated payment companies have access to the infrastructure they need to lower costs for American consumers?
So thank you, Representative. I look forward to working with you on any details of your legislation without picking sides. What I would say is the payment system that the Federal Reserve supports needs to be resilient, needs to not play favorites, needs to be able to withstand shocks and needs to be reliable and accessible so that we can do our part to ensure that the payment rails in the United States are strong. I would make a distinction between that and any payments that interact directly with retail customers. This is a business that the central bank needs to and should stay out of. A competitive banking system, a competitive payment system provides huge benefits to the U.S., so I wouldn't want to infringe on the businesses and practices of the private sector.
I appreciate that. As you know, I took my team and I talking to the stakeholders quite a bit since last year until we introduced it in a bipartisan way. So I look forward to having that conversation with you. But I think we agree that across the board, we need to modernize and reevaluate how we consider banking charters to ensure that our financial system continues to be the most competitive in the world. So to that end, I just want to let you know that PACE Act is, again, in response to President Trump's executive order. And when you know that the U.S. is the only G7 country that does not have a system that allow fintech or non-banks a direct access to traditional payment networks, I think it's really important that we work together. And I do want to work with you on this issue of a master account access and the PACE Act. So I hope we can take the time, and I hope that you and your team, now that you are in office, to review it, and we hope to get your technical assistance on the PACE Act from your team shortly. Thanks. Another major priority of mine has been expanding access to workforce housing. Last week, as you know, we, as part of the 21st Century Road to Housing Act, I was able to increase the cap for investments in community lending and affordable housing. So as we continue to build on that momentum of expansion of the low-income housing tax credit, one thing that has caught my eye is the 100% risk weight for these types of investments in the proposed Basel Endgame rulemaking. Historically, these types of investments are extremely low risk, with very few resulting in foreclosures. So, Chairman Walsh, can you offer any insight into how you are considering the risk weight for these investments?
Mr. Chairman, I'd invite you to answer that question offline as the gentlewoman's time has expired. Chair recognizes the gentlewoman from Michigan. Ms. Tlaib, you're recognized for 5 minutes.
Thank you, Chairman. Thank you, Chair, for being here. You know, public transparency and democratic accountability is important to American people, not just to my residents at home. So just bear with me here in regards to this. You know that you've said that the Fed should talk less to reduce the influence on financial markets. Is that correct?
When the Fed speaks, it should matter.
Yeah, but there's a difference between giving less guidance to traders, you know, but explaining less to the public is what I'm concerned about. You know, these hearings exist because Congress is paired with the dual mandate with, you know, we have a duty to report on progress towards various goals. So, you know, again, it matters what kind of communication you reduce. So, for instance, you know, transparency in regards to, like, one of the things that bothers me is, like, you as the Fed chair has to publish the calendar, your calendar, right? Correct?
I believe subject to FOIA requests, we turn over, consistent with
Yeah,
FOIA,
but when
the
you-
appropriate entries.
But when you provide it, you don't actually put the topic of what those meetings were about.
So I've only been in office 7 weeks, so I haven't even provided it yet, but we'll fully comply, we'll fully comply with the law when such requests are made.
Yeah, I just think, you know, I think what the American people want, or anybody, is not just who are you meeting, but what the topic is, I think is important. So let's get back to what you provide to the public. So when the Fed communicates less, how does the public or the committee judge whether or not the evidence was, or the method was responsibly implemented?
So I draw, Congresswoman, an important distinction.
Yes.
Our number one objective is getting policy right. And if we get policy right, we can deliver lower prices. Transparency and communication is usually quite essential to do that. So I'll draw a distinction between our internal deliberations, where we get to have a good family fight and talk about the hard issues, and then our decisions. I think our decisions are things that you should know everything about. You should understand our rationale. We should be responsible and accountable. And if we don't deliver what we say, you should hold us account.
Yeah.
So in that, I
But
favor
how you
full
del-
transparency.
Yeah, so it sounds like you will be open to absolutely being, regards to the method and the rationale and the thinking behind the decisions.
Yes.
Okay. So if, again, this is something of a concern for me because when people say that to me, I'm like, if the Fed speaks less than public, then the words that are spoken in private to banks and invited audiences and off-the-record settings, that's why the calendar, it's like, don't just provide the calendar, provide what topic, because I think it's important. So what specific steps will you take so that a quieter Fed, because that's what you sound like you're towards, you want a quieter Fed, isn't a Fed heard only by the well-connected?
So I don't think there should be any special dispensations to the well-connected. My judgment is what matters most is the real economy.
Yeah.
Financial prices then can capture what's going on. My message more broadly to you, but also to people that are in the cottage industry of following the
I know,
Fed.
but the regular person out there is not going to get a meeting with you, not going to know a lot of these things. That's why I'm asking. So will you at least commit to publishing readouts of your meetings with the market participants?
I'm committed to follow the law, and
But
I'm
we should
committed
know
to
what
do
you're
more
telling-
than that.
But we should know what you're telling them, because not the 750,000 people in my district can get a meeting with you, and you want to talk to the public less. So I don't know. I just want to make sure that we understand the intent and the decisions that are being made. So in 2025, you said that Fed had, quote, redefined its legislative remit and signaled a willingness to accept like a higher inflation, and all that stuff really, my folks are thinking this isn't going to impact employment, this is going to, what is going on here?
Yeah, so what went on is the Fed changed its academic framework and its operational framework, and it led to higher prices, which did more harm to the least well-off among us than any policy that I could have imagined, and so that's why we have to reform it.
I know.
The Fed's begun that reform, and we're going to continue it.
Okay, last question. At your June press conference, you said that there is, quote, no cruel choice, that strong employment and low prices are mutually compatible. If there's no trade-off, pursuing maximum employment costs you nothing in terms of inflation. So, Chair, what concretely are you doing to pursue maximum employment right now?
So concretely, what we're doing is going to deliver price stability, and when we deliver that, households and
Explain that
businesses will
more.
be stronger.
Explain that more.
So I can think of few things.
Gentlewoman's time has expired, and I invite the
Chairman,
chairman to
darn it.
carry on that explanation in writing, and I thank the gentlewoman. The chair recognizes the gentleman from Wisconsin, Mr. Fitzgerald, for 5 minutes.
Chairman, thank you so much for being here. Thank you. I am trying not to be redundant on the questions you've already been asked, but Chairman, the June FOMC statement reaffirmed the Fed's policy of maintaining ample reserves in the banking system. While your balance sheet task force is reviewing the benefits and risks of that framework, so if you go back to 2019, when reserve scarcity kind of contributed to stress in the short-term funding markets, what market indicators, in your opinion, should the Fed watch most closely to determine whether balance sheet reduction is moving too quickly, which is a concern?
So, Congressman, we have to look at a mosaic of information to judge how best to conduct policy. I wish there were some simple rules that we could rely on for monetary policy or clear and simple rules on the balance sheet. What we have to do right now is go back to first principles and ask ourselves whether this large balance sheet of a duration that is much higher than it was some years ago, whether that's consistent with good monetary policy. And then we're going to ask ourselves whether there's a better regime, and finally, how to get from the current regime to something else. We haven't prejudged any of those answers, but the goal isn't to be disruptive to markets. It's such that markets, the banking sector, and the real economy can understand the change and have time to adjust if we end up doing so.
Thank you. Chairman, in the interest of time, I'm going to yield my time back.
I thank the gentleman. Chair recognizes the gentleman from New York. Mr. Torres, you're recognized for 5 minutes.
How are you, Chair? Thank you for your service. During your Senate confirmation hearing on April 21st, 2026, you said, quote, "The measures I prefer looking at are things that are called trim averages, where we take out all of the tail risk. Separately, on May 31st, 2026, the Wall Street Journal reported that you want the Federal Reserve to give greater weight to the Dallas Fed's trim mean PCE. And so I want to offer a critique and then have you respond. Trim mean PCE lagged behind core PCE in detecting the inflation shock that began in 2021. Core PCE crossed the Federal Reserve's 2% target in March 2021. Trim mean PCE did not cross that same threshold into July, a 4-month lag. By February 2022, core PCE had risen to 5.4%, while trim mean PCE stood at only 3.6%, a divergence of nearly 2 percentage points. And so here's my question. If trim mean PCE detected the inflation shock later, understated its severity, and diverged from core PCE by nearly 2 percentage points, why should the Fed place greater weight on it when setting monetary policy? And to put a finer point on it, your core criticism of the Fed is that it was behind the curve on inflation. That same criticism can be leveled against your preferred measure on inflation. So why the disconnect?
So none of those are very good measures of underlying inflation. That Wall Street Journal story that you referenced is incorrect, that I have a preferred measure from one of the reserve banks. If I had a preferred measure, I wouldn't have called for a task force to go back to first principles, and the data task force will be looking importantly at inflation measures. My view is that we need new measures to understand the underlying changes in inflation. Am I interested in what's the mean or median price of a good in a big box retailer? You bet I am, and none of these measures capture that. I am super interested in finding new measures to do a better job to help us inform our decisions so that the inflation of the last 5 years don't continue.
Now, you have repeatedly described inflation as a choice. A simple yes or no question. Do you mean a choice by the Federal Reserve?
I mean a choice by the Federal Reserve and fiscal policymakers both, but I'm not trying to push the responsibility onto you. The Congress said that we're in the business of ensuring stable prices, and that's exactly what we're going to do.
So combating inflation is part of the Fed's statutory mandate, and you view inflation as a choice by the Fed. Combating unemployment is also part of the Fed's mandate. Do you view unemployment as a choice by the Fed?
We have no legislative orphans. We can't just take one part of the statute you give us and disown the others. I will just add a touch of complexity. We have more control over the price level ourselves than we do the unemployment rate. We have some say there, but so do all the policies that you and your colleagues put into place.
But obviously, if you aggressively raise interest rates, that could have the effect of causing unemployment. So in that sense, it's a choice, right? There are multiple forces that shape both inflation and unemployment, and the Fed is one among many. Quantitative easing. Do you believe quantitative easing is inherently inflationary? Yes or no, and then?
That question I can answer simply. I don't think it's inherently inflationary, especially if we adopt quantitative easing in the depths of a crisis. It can often provide liquidity to markets that need it.
So from 2008 to 2014, the Federal Reserve's balance sheet grew by a factor of 5, from about $900 billion to about $4.5 trillion. Yet over the same period, average headline PCE inflation was 1.7%, and average core PCE inflation was 1.5% below the Fed's 2% target. So the notion that quantitative easing may be inflationary fails to explain the non-inflationary effects of a multi-trillion-dollar five-fold expansion of the Fed's balance sheet from 2008 to 2014. Can you explain that for me?
Yes, Congressman, I can. If the balance sheet expansion were our only policy tool, then that is a reasonable conclusion to draw. But we have several policy tools. The dominant one is interest rates. And so we need to think about both of them in the context of monetary policy.
I want to quickly interject. Do you believe changes in the size of the Fed's balance sheet have an effect on inflation comparable to changes in interest rates?
You had me except for comparable. They can substitute for each other. They can complement each other.
But you don't see them as comparable?
But the balance sheet, they have different effects. Okay. The balance sheet tends to work more through asset prices first.
And I want to
interest
interject.
Rates more through the real economy.
Do you acknowledge that IORB weakens the relationship between the size of the Federal Reserve's balance sheet and inflation?
Not precisely. I don't know if I can answer that fully in one
You
second.
need to answer it in writing, and it'll be very interesting because these were good questions.
I look forward to doing that. Thank you.
With the time we have remaining that the chairman's allocated us, the chair now recognizes the chairman of our subcommittee on housing and insurance, Mr. Flood, and I recognize you for 4 minutes.
Thank you, Mr. Chairman, and thank you for being here, Chairman Warsh. I'd like to begin by emphasizing the importance of the independence of the Federal Reserve. Markets rely on our financial system and the dollar as a stable, safe place to put their money. The stability of our financial system is at the center of our global influence. Our adversaries know that if they can break our debt markets, if they can break the dollar, they can remove one of the largest and most significant advantages we have as Americans. The strength of our system and, in turn, our ability to stand up against foreign adversaries that seek to destabilize it is partially a function of having an independent Federal Reserve. If we lose an independent Federal Reserve, we will lose the confidence of people around the world that use the U.S. markets and the U.S. dollar as a safe haven, and that would be devastating for our economy and the economic security alike. Thank you for your work. I want you to know that I strongly support your ability to operate in an independent fashion. And to that end, Mr. Chairman, before I get into the rest of my questions, I wanted to give you an opportunity to speak on the importance of an independent Federal Reserve.
Thank you, Congressman. I'm happy to do it. The Fed will remain independent on my watch. Fed independence is essential to the proper conduct of monetary policy, and I expect and will ensure that monetary policy is independent over the 4 years of my term. And like you, I think it provides extraordinary benefits in everything we do and strengthens the role of the United States and the U.S. dollar in the global economy.
Really appreciate that. Next, let's talk about the Federal Reserve's balance sheet, kind of following on what Mr. Torres was talking about. I've had longstanding concerns with the effects of the long-term effects of the Federal Reserve's balance sheet. In particular, I also worry about the use of quantitative easing in times of economic trouble. It can take a long time to unwind, leading to a Federal Reserve balance sheet that continues to grow and grow over time. Mr. Chairman, would you mind commenting just broadly on the use of quantitative easing in monetary policy?
I'd be happy to do it, Congressman. In periods of crisis, when markets aren't clearing, I am willing to be quite aggressive in what the Fed does with its balance sheet, the assets that we buy as necessary in unusual and exigent circumstances. But when crises are over, monetary policy, in my view, should be driven almost exclusively by interest rate policy. One of my former colleagues said it best when he said, interest rates get in the cracks. I'll go on to say, interest rates don't favor one class of people versus another. They don't favor those that have financial assets more than folks that are living off their bi-monthly paychecks. So I like interest rates as the dominant ways to make monetary policy, and I'd prefer, all the things being equal, to use balance sheets when the crises are real. However, I've inherited a very large balance sheet with a very complicated set of assets, and I am open-minded to reforms, as are my colleagues, and I'm keen to continue to work with this task force to achieve that.
Real quick, and I'm skipping to the end because this question matters a lot to me. I have a lot of community banks in Nebraska. It's the lifeblood of agriculture. Can you talk about how you see supervision working and respecting the role of a community bank, especially in rural America?
Congressman, as I mentioned to you in your office, I'm a big believer in the diversity of financial institutions. The U.S. economy benefits enormously by not having a half a dozen big institutions at the top do everything for everybody. The ag community, other communities are well served by the banks that are closest to them. Supervision and regulation needs to take that into account. The thousands of banks that we have are an enviable good, and the Fed needs to do what it can to support them.
Thank you very much, Mr. Chairman. I yield back.
Gentleman yields back. I want to thank Chairman Warsh. This is Season 1, Episode 1 of Warsh at the Fed. We look forward to Episode 2 tomorrow. We want to thank you for your testimony today. Without objection, all members will have 5 legislative days to submit additional written questions to the chair. The questions will be forwarded to the witness for your response. Chair Warsh, please respond no later than August 18th, 2026. And with that, this committee hearing is adjourned.
Thank you.